Okay, we are on the record now for Wednesday's civil docket, June 30th, 2021. Happy Wednesday, everyone, and happy last day. And as Mr. Brunella was saying, it's the last day of June. 6 months has flown by. 6 months that we've been on the bench, and what an experience it's been. So let's get started. Let me start with Attorney Catherine Julia.
Good morning, Your Honor.
Good
I'm
morning.
here on number 26 on the court's docket. It's Julian Salinas versus Miguel Salinas, CL 191690I. I am making an appearance not only for myself, but also opposing counsel, Jesse Hernandez, who is out of town and unable to attend this morning. This case, we are completely finished with discovery, and the only thing remaining is we need a trial date.
Okay, so you'll return on September 29th, and by that time, I should be able to give you your DCC date in order to be able to give out trial dates.
Perfect. All right, so will that be September 29th at 9:30 a.m.?
Yes, ma'am.
That's all I have. May I be excused?
You certainly may.
Thank you.
Thank you. Attorney Willie Hernandez?
Morning, Judge.
Good
Here
morning.
on number 30, CL 200178, Judge Juan Campos versus Fernando Campos.
Okay, and what is your announcement, counselor?
And Judge, we're actually going to mediation on this case, and so maybe we can just do another status conference in the next probably 60 days.
When is your mediation set for?
We're going to mediate within the next 30 to 45 days, Judge. We're still picking a mediator.
Okay. If you can't agree to a mediator, then the court will appoint one to you. Just let us know.
Sure, Judge, not a problem.
Okay, so then if it'll be within the next 45 days, you can come back on August the 25th
You sure can, Judge.
and let us know what happened.
Will do, Judge.
Okay, that'll
Thank
be
you,
at
Judge. Is that
9:30.
30 in the morning?
Yes,
Thank you, Judge. Can I be excused?
we certainly may.
Thank you, Judge. Be safe.
Thank you. Attorney Daniel Sorrells?
Good morning, Judge. Here on number 23 on the court's docket.
Okay. CO 172640-I, Rodrigo Santa Ana III versus Southside Independent School District et al. And what is your announcement?
Good morning, Judge. For the record, Daniel Sorrells representing the plaintiff, who is also here somewhere on Zoom. I saw him here, Judge.
Good morning, Your Honor. Mike Saldana representing Southside Independent School District, San Antonio Southside. We're present, Your Honor. This is a status conference. I believe that we filed a motion to dismiss for warrant of prosecution that's before the court, and I believe Mr. Sorrells filed a response. I believe that's where we're at right now, Your Honor.
That's correct, Judge. We had also filed it in our response, just a request for the court to issue a ruling on a motion that we had filed and had heard in County Court number 2. It was a motion to remove this case from the expedited case track. That motion was heard several times in court 2, similar to the motion to transfer venue. We got a ruling on the motion to transfer venue, but we've never had a ruling on that motion. So I'm not sure if the court wants to reset for an actual hearing on it, or if the court can make a decision on it, Judge.
Okay, I refreshed my memory, but I thought I had stated that if, obviously I can't rule on something that I didn't hear unless you were going to provide me the transcript.
Your Honor.
If you want to have that, if you want a ruling on that motion, then you need to file an order resetting that motion. Mr. Saldana, you were saying?
Yes, Your Honor. I think we're kind of getting ahead of ourselves. What's before the court is the status and whether this matter should even proceed. This matter has been on file for a significant amount of time. It was filed back in June of 2017. And it basically, the plaintiff's first attorney, I think, was a relative, didn't do much on it. Took us a while to get a motion to transfer venue heard. We finally got it heard. It was dismissed. I mean, it was denied. I'm not quite sure when Mr. Sorrells came on, but it's been a while. And basically nothing has been done on this case for 48 months. And the motion that we have before the court today, which I think can be dispositive to whether this case should go forward or not, is our motion to dismiss for want of prosecution. And if Your Honor would indulge me about 2 minutes, I can summarize my arguments for that. I've prepared for the court in the motion. It's a very short 3-page motion for the.
Okay, hold on for me, please, because I was in my Odyssey and it kicked me out. So your motion, Mr. Saldana, you said you filed a motion to have this dismissed for want of prosecution.
Yes, Your Honor.
Okay, did you file an order setting hearing on that? Because I don't have that set for this morning.
Your Honor, what I did not, because at our last hearing, I believe, I'm not sure if it'll be reflected in the docket entry that may have been made, is that the court ordered us to do so and set this status hearing to consider that. And based on the oral instructions that we got from the court at that hearing, and I know it's been a while since we've had that hearing, Your Honor, and I would not expect it. So I would expect it to be, it may have been in the process of, it might be in the form of a docket entry. I'm sure, Mr. Sorrells, can you correct me if I'm wrong on that in my recollection of the last hearing?
From my recollection of the last hearing, we were trying to talk about, possibly resolving it amongst ourselves, and then, get everything set for what we wanted for the court. So I know that at the last hearing, the dismissal for want of prosecution was brought up along with my, request to get this off the expedited track. And I think that's why we got it set for another status, just to see where we are. But I think opposing counsel is correct on the dismissal of want of prosecution and kind of see where we are.
Okay, these are the notes that I see, which that you all did let us know that your motion to transfer venue was denied, and then both of you requested a jury trial, or announced that you all were looking at a jury trial. But I understand that, look, I have this set for a status conference, so I needed to know what's going on. So if you have a motion that hasn't been ruled on, I'm not sure why it never was ruled on, but I didn't hear that motion. So you're going to have to argue, if you want to pursue that motion or urge it, I'll have to hear the arguments again. So you'll have to file an order resetting hearing on the motion that you want me to hear. If there's any outstanding motion that also needs to be heard, file an order resetting hearing. We'll set them all in the same time, and then I'll let you all argue your outstanding motions, and then I'll make a ruling. I usually will make the ruling within 14 days if I don't do it off the bench.
That's perfect, Judge. If I remember correctly, I think it was a 2-3 minute argument on my motion, so it's not going to take up too much of the court's time.
Well, that's not the first time I've heard that, but we'll take it as it comes. Okay.
Your Honor,
Yes.
I will represent to the court that last time there was a overwhelming docket in which we were the court was absorbing. We understand from another court, and we understand the the burden that it may have put on the bench, and we fully understand and will cooperate with the judge's instruction, with your instructions today. I will get together with Mr. Sorrells and submit an order setting hearing on the outstanding motions. We will identify those motions clearly for the court. I believe it'll be my motion to dismiss for want of prosecution. Mr. Sorrell has a motion to remove from the expedited docket, and he may have, I'm not quite sure, a discovery issue. We will put that together, file it with the court, and get another date from the court, Your Honor.
Okay. So go ahead, and how much time are y'all gonna need to do that?
I won't need, Your Honor, more than 30 days. That, you know, it shouldn't take us very long to do so.
Okay, what I'm gonna do, instead of setting you for another status conference, because I need to hear those motions, I'm going to set a tickler for August the 27th to make sure that those motions have been filed by that day, or your order resetting hearings. That doesn't take long to just file an order resetting hearing. And then we'll take those up instead of setting you for another status.
That'll be perfect, Your Honor. August 27th is acceptable to the defendant.
Okay. Anything else?
I believe that's all I have, Judge.
Okay. If
Nothing
you don't
further, Your Honor.
file,
May be excused.
yes. Okay.
Thank you.
Okay. Attorney Belinda Anzaldúa?
Yes, good morning, Judge. I have number 3 on your civil docket is an agreed divorce.
Okay, that's F 1287-21-9 in the matter of the marriage of Felix Alonso and Maria Alfaro Silva. Is someone on for Mr. Guerrero's office?
I'm right here, Judge. Good morning. I'm here for the respondent in the case. It's an agreed to divorce.
Okay, are both parties on?
Judge, I believe it's just the petitioner, Judge. He should be present and he needs the assistance of an interpreter.
Okay, Mr. Felix Alonso. Ms. Castañeda, since he needs the services of an interpreter, can you please ask him to unmute himself and announce himself?
Mr. Alonso, ¿se puede quitar el botón de mute y anunciarse? Felix Alonso.
Do you see him on the screen? Oh, there he is.
Yes, ma'am.
Mi nombre es Félix Alonso.
My name
Okay.
is Felix Alonso.
Please ask him to raise his right hand.
Por favor, levante su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God, sir?
Jura que el testimonio que va a dar es la verdad, toda la verdad y nada más que la verdad.
Sí,
Yes,
sí, juro.
no, I swear.
You may proceed.
Thank you, Your Honor. Mr. Alonso, can you please state your full name for the record?
Mr. Alonso, por favor, diga su nombre completo.
Félix D. Alonso.
Félix D. Alonso.
And Mr. Alonso, you're asking the court at this time to sign a divorce decree. You're divorcing your wife, María de Consuelo Alfaro Silva.
Mr. Alonso, en este tiempo usted está pidiéndole a la corte que firme el decreto del divorcio para divorciarse de la señora María de Consuelo Alfaro Silva.
Sí,
Yes.
Okay. And you, Ms. Silva, were married on June 9th, 2017 and ceased to live together as spouses on February 5th, 2021.
Usted y la señora se casaron el día 9 de junio del 2017 y se separaron el día 5 de febrero del 2021.
sí,
Yes.
And Mr. Alonso, at the time that you filed your petition for divorce, you had lived in Texas for the last 6 months and resided in Hidalgo County for the last 90 days.
Al tiempo que usted metió su petición, tenía más de 6 meses de vivir en el condado de Hidalgo.
sí,
Yes.
Okay. And you're asking for this divorce because the marriage has become insupportable because of discord and conflict of personalities?
Y usted está pidiendo el divorcio porque se han complicado por discordias.
sí,
Yes.
And there's no expectation of you two getting back together.
Y no hay expectaciones de que ustedes se van a volver a juntar.
no,
No.
And there was no children of the marriage and no adopted children. Is that
Y
correct?
no hubo niños en el matrimonio y no niños adoptados.
no, no hubo nada.
No, we didn't have any.
And she's not pregnant.
Y ella no está ahorita esperando bebé.
No,
No.
And you and Ms. Silva have entered into a agreed final divorce decree. Is that correct?
Y usted y la señora Silva han entrado en un divorcio de acuerdo, ¿correcto?
claro que sí.
Yes.
And you have agreed that you would be given the following property:
Y usted está de acuerdo en quedarse con la siguiente propiedad.
all the farm equipment,
Todos los equipos de farming.
En área agricultura.
Agricultura.
Sí,
Yes.
and that you would keep all the sheep and goats,
¿Y usted se va a quedar con los chivos y borregos?
sí,
Yes.
and you would keep all the household furniture that is already in your possession and that you have control of?
¿Y usted se va a quedar con las cosas que están en la casa y que usted tiene control?
y lo que es mío, sí,
Yes, what's mine.
And you're keeping all your clothing, jewelry, and personal effects that are in your possession and in your control?
¿Y usted se va a quedar con su ropa, joyería que está bajo su control?
sí,
Yes.
And you're going to keep all the cash that is in your possession and in your name?
¿Y usted se va a quedar con el dinero que está en su posición y en su nombre?
sí,
Yes.
And any life insurance policies in your name as well?
¿Y aseguros que están en su nombre también?
también, sí,
Yes.
And you'll be keeping the 2007 Nissan Titan.
¿Y usted se va a quedar con la Nissan Titan del año 2007?
sí,
Yes.
And your wife will be keeping the mobile home that's already in her possession. Is that correct?
Y su esposa se va a quedar con la casa móvil que está en la posesión de ella, ¿correcto?
sí,
Yes.
And she's keeping all the mobile home furniture, furnishing, and appliances.
Y ella se va a quedar con las cosas que están en la mobile home adentro.
sí,
Yes.
And she'll also be keeping all the clothing and jewelry and personal effects that she already has in her possession.
Y también se va a quedar con la ropa, joyería y cosas personales que ella tiene en su posesión.
claro que sí,
Yes.
She'll be keeping all the cash in her possession and all the accounts in her name.
Y ella se va a quedar con el dinero que tenga en su posesión de ella.
sí, claro,
Yes.
In regards to livestock, she's keeping all the chickens.
Y con el ganado, ella se va a quedar con las gallinas.
sí,
Yes.
And she's also keeping the 2009 Ford Escape and the 2002 Nissan Frontier.
Y ella también se va a quedar con una troca de 2009 y un carro Nissan 2002.
sí,
Yes.
In regards to debts, you are going to be held liable of any debts that you made or are in your name from March 24th, 2021 till today.
En consta de pagos, usted se va a quedar con lo que usted tenía del marzo 24, 2021 hasta ahora.
sí,
Yes.
And she will keep all the debts and any loans under her name between March 24th, 2021 till today.
Y ella se va a quedar con sus deudas de la misma fecha, marzo 24, 2021.
sí,
Yes.
And the parties agreed that the home in Santa Cruz Garden subdivision is your separate property.
Y están de acuerdo que la casa en la Santa Cruz subdivision es propiedad separada.
sí,
Yes.
And it was acknowledged that that property was sold and that all proceeds remain your separate property.
y que esa propiedad se vendió y todo el dinero es de su propiedad sola.
Sí,
Yes.
And you agreed to give her $50,000 out of those proceeds.
Y usted está de acuerdo en darle $50,000 de ese dinero.
claro que sí.
Yes.
And that's all you're asking at this time, Mr. Alonso, is that correct?
¿Y es todo lo que usted está pidiendo este tiempo, Mr. Alonso?
Sí,
Yes.
And Mr. Alonso, you had the opportunity to go over the final decree and you already signed off on the final decree, is that correct?
Mr. Alonso, y usted tuvo tiempo de revisar el decreto y ya lo firmó, ¿correcto?
sí,
Yes.
That's all I have, Your Honor, and that decree has been signed off by all parties and attorneys and was filed yesterday, Judge.
Okay, Mr. Guerrero, do you have any questions of Mr. Alonso?
Not necessarily. We did receive, I guess I should ask him. If I can ask him. Mr. Alonso, you've already tendered to my client $25,000 of the $50,000 that you promised to pay. Is that correct, sir?
Mr.
Yes.
Alonso, usted ya le dio a la señora $25,000 de los 50 que le iba a dar.
sí,
Yes.
And the remaining balance, sir, are you going to pay it today by delivering a check in her name to my office?
Y el balance se lo va a pagar ahora para llevar un cheque a la oficina de mi oficina.
Judge,
sí,
I actually have that check and I'll be delivering it today also with the paperwork for the mobile home.
Okay. That concludes my questions, Judge.
Okay. Then, Mr. Alonso, do you believe that this is a fair and equitable division of your community assets?
Señor Alonso, ¿usted cree que esta es una división apropiada para los bienes que tienen?
sí,
Yes.
And are you asking the court to accept your agreement today, sir?
Y está pidiéndole a la corte que acepte su decreto?
sí,
Yes.
And are you asking the court for a divorce today?
Y está pidiéndole a la corte un divorcio?
claro que sí.
Yes.
Okay, then the court will accept the agreement as testified to into the record, will grant the divorce. And as soon as I'll request that divorce decree to be forwarded to my queue for my signature.
Thank you, Judge.
Thank you, Judge. May we be excused?
You certainly may.
Thank you. Have a good day.
Judge.
Thank you likewise. Attorney Roel Esquivel?
Good morning, Judge. I'm standing in for Mr. Felipe Garcia on number 28 on your docket, CL 194689I.
Okay, that's Magda Cerda versus Stephen Healy et al. Is there
Yes.
anyone here for the defense? I don't know who the attorney for the defense is.
Judge,
don't
I
have it.
looked at the answer and it shows an individual by Damon Garcia and Mr. Defense Counsel, and Mr. Felipe Garcia, a plaintiff counsel, is presently mediating a case, and he's asking the court to consider allowing them more time on this case. My understanding is they're going to mediate. So that's the only information I have at this point for the court, Judge.
Okay, so did he happen to tell you when they were mediating this?
Judge, I sent him a text this morning. He asked me late yesterday, so I'm sort of behind the 8 ball, so to speak. Don't have all the information that should be required, that is required to make the proper announcement. So I do not have that information, Judge. If Your Honor wants to recall the case, I can wait for his response to see if he can respond.
Well, I was just going to say, it's because the next status, I usually don't like to give it until after they've attended mediation, so that way we know where we are as far as if they're going to proceed to trial or what. But
I did
I
ask
just
Mr.
wanted-
Garcia, I'm sorry, Judge. I did ask Mr. Garcia how much time he's requesting, and he requested 6 months. I think that's a bit much, but that's what he's requesting.
yes, that is a bit much. And also because I would expect that a case of that age is, I mean, they have to have already been moving along in the discovery process.
Yes, Judge.
So, I mean, they may be lacking some depositions, but what I'll do is, I'll have this reset for August the 25th. And at that time, hopefully they've already at least moved along on the discovery process, or they can let me know where they're at and if they've attended mediation, and if not, when they will be attending mediation.
Very well, Judge.
Okay, so we'll see them back here on August the 25th at 9:30.
Thank you, Judge. I'll relay that information to Mr. Felipe Garcia.
Okay, thank you.
Thank you. Bye.
Okay, Attorney Kevin McGuire.
Thank you, Your Honor. I represent Ford Motor Credit. We're number 21 on your docket.
Yes, sir.
This is a reset of a motion for default judgment, I believe about a month ago. The issue there was a blank return of service on file. I do have a copy if the court needs me to screen share, or the court can check its record. We did try to refile. We have a copy of showing that that Mr. Artemio Chapa was served.
Okay, give me one moment.
Okay.
Your Honor,
Yes.
it is on file. It was filed January the 14th of 2020 at 2:45.
With the correct information?
Yes, ma'am. And it was served by posting. The citation was by posting, Your Honor.
Okay.
It came to hand September 28th, 2019 at 9:17 p.m. And it was served January the 13th. It was posted January the 13th, 2020, and it was returned the 14th.
Okay. I think the issue the last time was whether he had received notice for the motion for default judgment hearing. And now I think that's what you filed back in May, correct? Letting him know?
Yes, we did.
Okay, I saw that. Okay. That was what the issue was. Okay. Well, now that you have your proof of notice that he did receive notice for the motion for default judgment set for today, you prepared to move forward?
I am, Your Honor.
Okay. And so let me call CL 210209-I Ford Motor Credit versus Artemio Chapa. Mr. Damian, can you please call Mr. Chapa's name
Yes,
out
ma'am.
3 times?
Artemio Chapa, Artemio Chapa, Artemio Chapa.
Okay, the defendant's name has been called out 3 times and no response. You may proceed.
Thank you, Your Honor. The defendant purchased a 2018 Ford F-150 on February 15, 2019 by written agreement through Bogus Motor Sales II, LLC. The written agreement gave the plaintiff the right to repossess the vehicle in the event of default. There was a payment arrangement under contract for 72 monthly payments at $637.56 per month starting April 2nd, 2019. The last payment received by the plaintiff was on August 31st, 2019. This was the event of default. The vehicle was repossessed on December 3rd, 2019. The vehicle was then sold at Mannheim Auction House on January 15th, 2020 for $30,700. Pursuant to the Texas Business and Commerce Code, the defendant was sent the notice of sale and the statement of sale by regular first-class mail, postage prepaid. After all lawful credits deductions, a deficiency amount remains due and owing in the amount of $11,122.22, for which plaintiff seeks judgment, plus court costs and attorney's fees of $500, which reflects 2 hours of legal work at $250 per hour. This legal work is considered reasonable, necessary, and customary for this case type. Plaintiff respectfully seeks judgment in these amounts. Nothing further, Your Honor.
Okay, you have an order that was on file on April 19, 2021. Is that the default judgment order you
That's
want
correct.
signed?
Yes, Your Honor, that's correct.
Okay, then the court will take judicial notice of all the documents in the court's file. And we'll find that the defendant was properly served and received proper notice for today's hearing. We'll grant the relief requested by the plaintiff, and I'll ask for that default judgment order to be sent to my queue, and we'll sign off on it.
Very well. Thank you, Your Honor. May I be excused?
You certainly may.
Thank you. Have a great day.
Thank you. Attorney Paloma Barreiro?
Good morning, Judge. Can you hear me?
Yes, ma'am, I can.
Okay, perfect. I got a new Zoom camera, so I'm just making sure. Paloma Barreiro on behalf of petitioner Hortensia Garcia, that is F1495219.
Okay, that's number 5 on the court's docket, and the respondent is Luciano Lopez.
Yes, Judge, this is an agreed divorce. Mr. Lopez is 73. He was having trouble with the Zoom. I did give him the phone number to call, but he does have a flip phone, so he couldn't figure out how to dial in as well. If the court would give me permission to call him on speaker, I can do that, or if there's another form that the court would prefer.
Did he already sign off on the decree?
He hasn't signed off officially, Judge, but I was going to put the testimony on the record and prove up the questions.
Sure, you can get him on the phone. That's fine.
But he did say he would sign it and we could go forward without him unless the court would want me to call him. We can do that as well.
Okay. Normally what I do require is at least if the divorce decree has not been submitted with all signatures prior to the final hearing, then both parties have to appear.
Yes.
However, if you're telling me that he will sign off on it and he's agreed to the terms that you will be testifying to today, let me see if we can move forward. Hold on, let me pull up her case real quick.
Okay, Judge. He filed an answer pro se.
Oh. Okay, although I do see that he didn't sign the certificate of service on the answer, that's normally, of course, that would be considered defective, but it's moot if he's going to be agreeing to the terms of the divorce today. So if you want, you can either get him on the phone and he can testify that that's the agreement, or as an officer of the court, if you're telling me that he's notified you he'll sign off on it, that's fine. I'll go ahead and take your client's testimony.
Yes, Judge, as an officer of this court, I'd like to inform the court that he did say he would sign off of it and he is in agreement.
Okay, so is Miss Carrasco English speaking or Spanish speaking?
Yes, she needs the services of an interpreter. She's a Spanish speaker.
Okay, Miss Carrasco, please raise your right hand. Miss Castañeda,
Por favor, levante su mano derecha.
do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God, ma'am?
Jura que el testimonio que va a dar es la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes.
You may proceed, Miss Barreiro.
Thank you, Judge. Miss Carrasco, please state your full name for the record.
Miss Carrasco, por favor, diga su nombre correcto.
Hortensia García Carrasco.
Hortensia García Carrasco.
Okay, and before filing your petition for divorce, you've lived in Hidalgo County at least 90 days and in the state of Texas for at least 6 months. Is that correct?
Y antes de meter su petición, usted vivía en el condado de Hidalgo por 90 días y en el estado de Texas por 6 meses, ¿correcto?
Sí.
Yes.
And you married Luciano Lopez on or about May of 2002 and separated from him on or about August of 2011. Is that correct?
Y usted se casó con el señor López en mayo del 2002 y se separó en junio del 2011, ¿correcto?
Correcto.
Judge, correction, it's August. Not
¿En agosto del 2011?
Sí.
Yes.
And there's no chance of reconciliation of this marriage. Is that correct?
Y no hay reconciliación, ¿correcto?
Sí.
Yes.
And there's currently no children born from this marriage who are under the age of 18. Is that correct?
Y no hay niños menores de 18 años en este matrimonio, ¿correcto?
Correcto.
Correct.
And you're not expecting a child right now with Mr. Lopez or anyone else?
Y no está esperando un niño con el señor López o con otra persona, ¿correcto?
Correcto.
Correct.
And there's no community property assets that need to be divided within this marriage. Is that correct?
Y no hay propiedad en común para separar en este matrimonio, ¿correcto?
Correcto.
Correct.
And it's the agreement of the parties that Mr. Lopez will stay with his personal belongings that are in his possession, and you will stay with your personal belongings that are in your possession. Is that
Y
correct?
es de acuerdo que el señor López se va a quedar con sus cosas personales que están en su posición y usted se va a quedar con sus cosas personales que están en su posición, ¿correcto?
Correcto.
Correct.
And you will remain liable and responsible for any debt that's under your name, and Mr. Lopez will be liable and responsible for any debt that's under his name. Is that correct?
Y usted se va a quedar responsable por cualquier deudas que estén en su nombre y el señor López por cualquier deudas que estén en nombre del señor López, ¿correcto?
Correcto.
Correct.
And it is further the agreement of the parties that Mr. Lopez shall refrain from doing the following, which is stalking you in any form, harassing you in any form, communicating with you, or being at least 100 feet away from you, threatening you, or committing any harmful contact against you.
Y también está de acuerdo que el señor se va a mantener alejada de usted, cualquier comunicación, a no acercarse más de 100 pies para usted, ¿correcto?
Correcto.
Ms.
Correct.
Vadillo, is that going to be mutual?
Yes, Judge, that's mutual.
Is there a history of them being argumentative?
There's a history of physical violence and verbal violence. So that was the agreement of the parties.
Okay.
Okay, and then Ms. Carrasco, and you're asking the judge to grant the divorce today?
Ms. Carrasco, ¿usted le está pidiendo a la corte que le dé el divorcio hoy?
Sí.
Yes.
Judge, I have no further questions. And at this time, I'm asking the court to grant the parties divorce.
Okay. Ms. Carrasco, do you feel that this is a fair and equitable distribution? Oh, they didn't have community assets. Is that correct?
Yeah, no community assets, no child support, no children under the 18.
Okay.
18.
Are you asking the court then, Ms. Carrasco, to grant your divorce today?
Ms. Carrasco, ¿usted le está pidiendo a la corte que le dé el divorcio hoy?
Sí.
Yes.
And to accept the agreement as you testified to?
¿Y que acepte lo que usted ha testificado ahorita?
Sí.
Yes.
Okay. The court will accept the agreement approve the agreement as testified to on the record by Ms. Carrasco, and it will be set forth in further detail in a divorce decree to be submitted. How much time do you need, Ms. Paredo?
Judge, just 1 week.
Okay. I'm gonna go ahead and put a tickler for July the 16th,
Okay, Judge.
just to make sure that it's been submitted by that time by signature with both parties, please.
Yes, Judge. Will do. Thank you.
Okay, anything else?
Nothing further from this honorable court may be excused.
You certainly may. Best of luck to her.
Thank you.
Okay, Attorney Randall Gomez.
Good morning, Judge. I'm here on number 24 on the civil docket.
Okay, good morning. And that is CL 182182-I, Roxanne Montalvo versus Elisandra Elizondo.
Yes, Judge, and I'm here on behalf of the defendant.
And Your Honor, Mario Cisneros on behalf of the plaintiff in this case.
Okay, give me one moment. Okay, and what is the announcement, gentlemen?
Your Honor, we're here this morning for a status hearing. We've already conducted depositions. We went to mediation. Unfortunately, we were unable to get the case resolved. I believe my office filed a motion for a DCC so that we can set this case for trial, Judge.
Yes, that's correct.
Okay, when did you all mediate?
We mediated back in December of last year, Judge.
Okay, who did you mediate with?
Leo Salzman.
Mhm. That's correct, Judge.
Okay, so then you're wanting to be placed on the trial docket?
Yes, Judge.
Okay. So I'll have you come back on September the 29th at 9:30, at which time we should have a better picture as to how we're going to do the trial settings. And we will go in order. Yours is an older case, so you might be able to get in sooner than the rest.
Okay. So the DCC will be September 29th at
No.
9:30, Judge?
No, sir. You'll come back for an additional status conference, at which time we should be prepared to give good DCC dates so
Okay.
that we can have pre-trial and trial settings for you.
Okay, Judge. Sounds
Yeah.
good.
You all won't be going to trial on anything until next year, really, because we're having to do it in this manner because we still don't even know how the jurors are going to be reacting or what kind of pull we will have when we get back to it. So,
Okay.
okay.
Sounds good.
All right. So we'll see you back here on September the 29th at 9:30.
Thank you, Judge.
Okay, thank you. Attorney Greg Lopez?
Hello, Judge.
Hello.
I am on a case with it's a motion to withdraw from the other party, Judge. And my client is Luis Enrique Acosta. It's number 17 of your docket.
Okay.
And so the other party's counsel wants to withdraw. I'm not opposed to counsel withdrawing.
Okay, so it's F 3121-15-9 in the matter of the marriage of Luis Enrique Acosta and Saraviel Velez Marcial, and I have attorney Dora Garza.
Good morning, Your Honor. Dora Garza for the respondent, Saraviel Velez Marcial. She is present, Judge, and does need the services of an interpreter.
Okay, ma'am. And are you proceeding on your motion to withdraw?
She is aware, and as far as I know, Judge, she is in agreement. I am.
I'm sorry. It's because there's some interference. Can you repeat your announcement?
Yes, Judge, I am asking that Your Honor grant my motion for withdrawal. The motion is out at her request, Judge, and she is in agreement as a
Okay. Ms. Castaneda, can you please let Ms. Velez know that we will be, that I'm granting the motion to withdraw.
Ms. Velez, la juez va a firmar la petición de Ms. Garza para que se salga de su caso.
Can you ask her if she will be retaining new counsel?
Ms. Velez, ¿va usted a agarrar un abogado nuevo?
Sí, yo creo que yo le comenté a la abogada que no tengo dinero porque este caso se está alargando mucho tiempo y no tenía por qué alargarse. Entonces,
I told the attorney that this case is taking too long and I don't have any money.
Okay, just let her know that now she'll be pro se and that she will have to communicate with Mr. Lopez as if she was an attorney.
Ms. Velez, ahora se va a tener que comunicar usted con Mr. López y usted se está representando sola.
no, yo quiero que me den un tiempo para poder agarrar otro, saber si puedo agarrar otro abogado.
No, I need time to get another attorney.
Okay, Mr. Lopez, can you tell me what the outstanding issues are left on this case?
Your Honor, we didn't have a hearing too long ago on this case. At the last hearing, child support was set. My client was to pay child support. And I think a visitation order was entered, but we are still pending a final hearing. My client is still requesting that he be appointed the primary custodian of the child. Obviously, the parties have not agreed to this. It's also been mediation. So that is for the pending judge, a trial on that issue.
Okay, so are you going to be asking for a jury trial or a bench trial?
I'm going to ask for a bench trial, Judge.
Okay, then what I'm going to do is I'm going to give you a DCC date so we can get that set. And that'll give her some time. Ms. Castaneda, ask her how much time does she need to obtain a new attorney because her husband is still asking for custody.
Ms. Vélez, ¿cuánto tiempo necesita para conseguir un abogado? Porque su esposo todavía está pidiendo la custodia.
Sí, él está pidiendo y ya tenemos 6 años con ese mismo caso y no se ha podido terminar, por eso
Yes,
es
we've
que
had 6 years with the same case.
Tell her that to answer my question. I
Por
don't need
favor,
to give,
responda la pregunta.
un mes.
1 month.
okay. So Ms. Rivera, can you give me a date for DCC 30 days out so she can at least get new counsel?
Yes, ma'am. It'll be August, I apologize. July the 28th at 2:30.
Okay. Let her know that she needs to tell her new attorney that there will be a DCC on July the 28th at 2:30.
Le avisa a su nuevo abogado que va a haber una conferencia por teléfono con la corte el día 28 de julio a las 2:30 de la tarde.
Está bien.
Okay, and at that time, Mr. Lopez will go ahead and set the date for the bench trial. Okay, anything further?
Yes, Judge, I would like her address and phone number.
Okay, Ms. Castaneda, please ask her to put on the record her address and phone number.
Ms. Vélez, por favor, puede dar su dirección y su número de teléfono.
No le escuché.
Por favor, puede dar su número de teléfono y su dirección.
Mi teléfono es 956-599-0222.
My phone number is 956-599-0222.
Y mi dirección es 1109 Sur, La Joma Road, Mission, Texas.
¿Y el código postal?
78572.
My address is 1109 South La Joma Road, Mission, Texas, 78572.
Does she use email?
¿Me da su correo electrónico?
No tengo correo electrónico.
I don't have an email.
Okay, anything else, Mr. Lopez?
No, Your Honor.
Okay, then we'll have you on our DCC on July 28th at 2:30, sir.
Thank you, Your Honor. I'll be excused.
Okay, you may be excused. Ms. Castaneda, you can let Ms. Velez know that she's excused.
Ms. Vélez, se puede retirar.
Sí, gracias.
Ms. Garza, is your order granting on file? No, I think she got off. Okay, we'll look for the order granting and have that forwarded to my queue. Okay, Attorney Abel Hinojosa?
Judge, good morning. Number 33 on your docket, along with Gus Hernandez, who's on the screen, but he's muted.
Okay, F 3025-20-9 in the matter of the marriage of Marsha Padilla and Kenneth Dawson. And what is the announcement?
Evelyn Hinojosa, Ms. Marsha Padilla.
Good morning, Your Honor. I'll stand on this for Kenneth Dawson.
Judge, we mediated this case on June 11th. We did not successfully mediate, so I'm assuming all issues are still pending. We need a DCC judge. So this case I'm requesting a bench trial.
Okay, and when you mediated this case, Mr. Hernandez, were you already on it?
Yes, I had filed the notice of appearance, I believe, 2 weeks before the mediation took place.
Okay, so then you did appear at the mediation with Mr. Dawson?
Yes, I did.
Okay. So then are you all wanting to get this done for final, or are you needing temporary orders?
Judge, there's already temporary orders.
One at a time, counselors.
There are already temporary orders in place, Judge, so it should be for final.
Okay, Mr. Hernandez, you were going to say?
I was going to say the same thing, Your Honor.
Okay, so then we should have Ms. Rivera, can we add them to our docket on July 28th for a DCC?
Yes, ma'am, at 3 o'clock.
At 3. Okay, so we'll do a DCC on July 28th at 3 p.m.
Thank you, Judge.
Thank you, Your Honor.
Okay, you're welcome. Have a good day.
Yes.
Okay, Attorney Hector Torres.
Good morning, Your Honor.
Good morning, sir.
Number 27 on the court's docket for today, Regina Richardson is filling in for Miss Monica Galvan, Your Honor.
Okay.
Good morning, Your Honor.
Good morning. CL 192996-I, Marco Antonio Hernandez et al. Versus Diana Puente Ramirez et al. And what is the announcement, counselors?
Your Honor, we're here for a status, and the status of the case, very briefly, is that written discovery has been mostly completed. If anything, Your Honor, we would just need to supplement, update it. Depositions are currently being scheduled. We've communicated with counsel earlier this month. Unfortunately, the last couple of weeks, we lost touch with our client, but we expect to get back in touch with her here very soon and finish scheduling those depositions, Your Honor. We do not have a trial date. We would like to have a DCC and put some deadlines in place. And we would also like to mediate this case after those depositions are taken. And I think there's going to be maximum of 3 depositions, short ones, Your Honor. This is an auto accident case.
Okay, and in which time frame are you looking at those 3 depots to be taken?
We hope to schedule them, I would say, within the next 45 days, Your Honor, 30 to 45 days. Again, I just lost touch with my client, but we'll keep trying to get a hold of her.
Okay. And then you still need to mediate it.
Yes, Your Honor.
Okay. Do you have anything to add, Ms. Richardson, or is that correct?
Your Honor, yes, Your Honor. Just echoing what Mr. Torres has relayed to the court. Ms. Galvan did indicate to me, and just for your information, Judge, she was logged on earlier. She's actually on a plane and had to take off. But we worked together, and she did tell me that deposition dates were sought and that they are actually working towards settlement. So I don't think that this case needs to be on a too long of a calendar, Judge, for your calendar purposes. Sounds like the case has been moving.
Okay.
Just Mr. Torres' issue with his client.
Correct.
Okay. So then when I'm gonna go, your discovery then is ongoing, and then you'll take those depositions within the next 45 days. I'm gonna order this to be mediated within 90 days with Melissa Carranza.
Okay.
And then work with each other if you need to move those deadlines in case scheduling of the depositions becomes difficult. And then what we'll do is, because I know you're working towards settlement, but in case you do end up going to trial, I'll have your return on September the 29th at 9:30, at which time you can advise the court as to how you're coming along, or if you're going to request a DCC to move forward with a trial setting.
Yes, Your Honor. Is this something that we need to put into an order, Your Honor, or not?
Judge, we're not, because we're not set for DCC as of yet. We're okay with the deadlines that have been read into the record by Your Honor. But whatever Your Honor wants to do.
Normally what I would do is send out an order of referral for mediation within the 90 days with Ms. Carranza. However, we're not at the courthouse, and that has tied my hands as to getting those order of referrals out. So I've been relying heavily on professional courtesies extended in between attorneys. I mean, it's the court's order. If you come into problems because of it, then I would suggest you reduce it to writing. But I trust that you and Ms. Galvan will work with one another with what I have stated on the record. So it's not necessary to put it into an order. And, now you know what I'm expecting. Just mediate it within the 90 days with Ms. Carranza. Depositions I'll leave to your scheduling and your calendar, and work with each other on moving those timelines if you need to because of scheduling.
Yes.
Okay?
Very good, Your Honor.
Anything else?
Not on
No,
this
not at
matter.
this
I just have one. I'm sorry. I just have one other matter.
Okay, Mr. Torres, if nothing else, you are excused, sir.
Thank you very much.
You're welcome, sir. Ms. Richardson, what other case do you have?
Your Honor, I have F 3270-12-9.
Good morning, Your Honor. I'm Pruneda.
It's
and I'm-
it's number 18, Judge.
Okay. Okay, in the interest of minor children and that, okay, and are you representing the petitioner or are you the ad litem?
Your Honor, I'm the ad litem, and I actually requested this hearing on behalf of my clients.
Okay, and Mr. Pruneda, you're here for the respondent?
No, actually, well, yes, the respondent, Mr. Pedro Avila, Your Honor, who's a biological father of the child.
And the mother is present, Judge. I see her on the screen, Vanessa Ortiz.
Vanessa Ortiz?
Yes, Your
Okay.
Honor. I believe her name is on the screen.
Okay, there I see her. Okay, and Ms. Ortiz, are you continuing to represent yourself?
Yes, Your Honor.
Okay, and so Ms. Richardson, what is your announcement?
Your Honor, I requested this hearing based on my communications with my client and what she wishes to have ordered by your intervention after a consideration of what the argument would be, I believe from me and from her dad's attorney, Mr. Aviles. Your Honor, it seems that there is quite a bit of discord between mom and my client. I can represent to the court that I have observed that seems to be the case at this point. I did assure my client that she's in good hands in this court. It would be a new judge, but that she's in good hands. Your Honor has extensive experience here. I would ask the court to consider some type of admonishment to mom and also some type of immediate intervention by way of counseling for mom and daughter. My client does have some requests, I think, in terms of what the current ordered visitation is with her mom, given the conflict and discord. Mom had actually left for, I think, reasons having to do with her current partner. She was out of the country for some time, I believe. She is here now, and I would hope is here in the spirit of unification with her daughter. But at this time, Your Honor, I don't think it's in her best interest to continue communication without some professional intervention. The prior court had addressed this, and Ms. Ortiz had indicated a lack of funds for that, but she did travel recently internationally, so I don't know really what the limitations would be if her interest is in sort of mending and trying to get to a better place with her daughter. As the court, I think, can observe, my client on the camera, she is older. She's old enough to communicate, Judge. She's very articulate, talented young lady. She has been very expressive and forthcoming with me regarding what she is requesting at this time. And I'm of the opinion that it actually is in her best interest to honor the greater substance of what she's requesting, which is to sort of put things on pause, to maybe try to reset if there is actual counseling that takes place. So that's what I'm asking of the court on her behalf.
Okay, hold on. Before I get into any of the arguments or anything like that. Okay, so how old is the child?
It'll be 16 in about 8
days.
days, Your Honor.
Okay, so what I'm gonna do is I'm gonna continue with the docket because we have some other quick announcements that I'm gonna take up. I'm gonna
Okay.
have you all excused for about an hour, get back on at about, I do have 2 contested matters at 11. Log back in at 11:30.
Okay.
And then I'll take you up, and we'll discuss it, at length. I'll let you all put on some arguments and move forward. So if you need to, you can either stay logged on and turn your camera off until I recall the case, or you can log back in at 11:30.
I do have other matters, Judge, so I'll go ahead and log off.
Okay, so you are temporarily excused and you can come back on at 11:30.
Appreciate it, Your Honor. Thank you.
Okay.
Thank you, Your Honor.
Thank you. Okay, Attorney Tim Davis?
Good morning, Judge. I'm here on I believe number 7 on your docket.
Okay. F 4121-19-9 in the matter of the marriage of Gabriela Flores and Ramon Flores. And what is your announcement, Counselor?
Judge Tim Davis, I represent the petitioner, Ms. Flores. She's here as well. This is a case, Judge, a divorce case. We mediated it. We settled all the issues with the exception of the issue of how do we characterize the marital residence, whether it's separate property or community property. And both sides, Mr. Ball represents Mr. Flores. We've each briefed that issue with the court, and I believe the briefs are on file.
Okay.
I'm
So-
here, Judge. Apologize, I stepped away from my camera.
That's fine. Okay, so then you're needing today then, in order to move forward, is it you're just needing the ruling on the characterization?
Yes, Judge.
Okay. Okay, did you all want to put anything else on the record before?
I know both parties are present. I didn't know if the court was going to have any questions for them or how you wanted to address it.
Okay, let me recall you shortly because I do have some questions with respect to this, but I think we can clarify it shortly. Okay?
Yes, ma'am. Thank
So
you.
just be on standby. Attorney George Rubio?
Good morning, Your Honor. We're here on number 29 on your docket.
Okay, sir.
Ricardo Benavides here on behalf of the defendant.
Okay, that is CL 200071-I, Julia Esparza versus Walmart. And what is the announcement?
Actually, Your Honor, we're here. We have a motion to withdraw as counsel. We had that set at our last status hearing. We forwarded copies of the motion and the setting. We still haven't had any response from plaintiff. Yesterday, we got the Zoom information. We went and delivered that, hand delivered that to her home, and still haven't gotten any communication. So we're going to urge that our motion to withdraw as counsel be granted. And then we filed a new order granting said motion for the firm. I realized that the order we had filed was just for me and didn't have the firm name. So I refiled an order this morning granting or asking the court to grant the motion to withdraw as counsel.
Okay, is there any objection, Mr. Benavides?
No, Your Honor, there's no objection to the motion. The only other thing I would ask for is we have a pending motion for summary judgment, and that's not set for today. We have filed another order requesting that it be set.
Okay.
And I would simply ask the court to go ahead and set it, if possible, within the next 30 days.
Okay, and then on that order setting hearing for your motion for summary judgment, does it copy her at her address?
I don't believe that it does, Your Honor. That's an excellent point.
Your Honor, if we may, the order that we filed has her address on the bottom. If the court is inclined to grant the order, I guess what I would ask is for defendant's motion for summary judgment to be set, let's say 60 days, so I can get our order granting the motion to withdraw, get the order setting the motion for summary judgment, so I can forward it to her. She doesn't have an email, she doesn't have anything, so everything has to be done by mail. So I think 30 days, maybe real quick, depending on how quickly we get the orders back, the physical orders. I think in 60 days, we can get those orders to her so she knows about the hearing. I mean, she hasn't shown up to anything, so I don't suspect she will. But I do think we need to give her notice. We did file a response, but honestly, as discussed last time, we really need her cooperation to fully respond. So I'd like to at least give her a date that she can appear if she wants to. But again, she hasn't made any communication or appeared to anything at this point.
Okay, what I'll do, let me have my bailiff call out Julia Esparza's name 3 times just to verify she's not here.
Yes, ma'am. Julia Esparza. Julia Esparza. Julia Esparza.
Okay, being no objection from opposing counsel and that plaintiff did not make an appearance, your motion to withdraw is granted, Mr. Rubio.
Thank you.
And what I would suggest, Mr. Benavides, is file an amended order resetting hearing with her address, copying her at her home address. And realistically, I will tell you that with the way that my docket is stacking up, it probably won't be until the end of August or the beginning of September that will set your MSJ.
Well, I will have the amended order sent out by first-class mail to Ms. Esparza by the end of today. And we'll have that filed with the court, and I'll just hope that the court can give us a sooner date.
Okay.
On the MSJ.
So what I'll do is I'm gonna set you for, you get all of that done and I'll have a tickler set for July the 16th just to double check that we've already set your motion for summary judgment.
Very good, Your Honor.
And as discussed, Your Honor, I did, the new order was filed this morning.
Okay, I'll ask for that order to be forwarded to my queue then.
Thank you, Your Honor. That's all we have. May be excused.
You certainly may.
Thank you, Your Honor.
Okay. Okay, I have it as Mike, but I don't have a last name.
Michael Schroeder, Your Honor.
Okay, how are you, sir?
I'm wonderful, Your Honor. How are you doing today?
Good, so you're here on number 32 on the court's docket, correct?
I am, Your Honor.
Okay.
And this is a status conference, and my client, I finally got around to filing a motion for summary judgment, motion for limine, motion for judicial notice, business records affidavit, and we need a setting. And I did also file, and the clerk helped me with this, filed a motion setting hearing on, or an order setting, a proposed order setting hearing on those motions. So we'd request that the court set hearing sometime after July 19th on the motion for summary judgment and the other orders, or the other motions.
Okay, that's CL 23084-I. And I have attorney Juan Guerra on the other side.
He was here.
Yes, he's on mute. Mr. Guerra?
Judge, yes. Good morning, Judge. Which case was this, Your Honor? Because I had two this morning with you.
Trinity Life Insurance versus Leslie Gomez et al.
Yes, ma'am. This is a status hearing. We're appealing this to the JP court, and we had asked for a jury trial. I don't know if he had filed, he said he'd filed summary judgments.
Yes.
When was those filed? I don't.
Those are filed on Monday of this week, and I email copies of everything to you, Mr. Guerrero.
Okay. So I still have with the 21 days to answer?
Yes, sir.
Okay.
We still haven't said it.
Okay, thank you, Judge. So don't scare me that when he said summary judgment, I said, oh, shoot, I didn't answer.
And Mr.
Okay.
Guerrero, I did look at the court's docket this morning. I did not see a jury trial request. But I may have missed it. But anyway, we would, at this point, Your Honor, request the court set the motion for summary judgment for hearing.
That's fine, Judge, as long as it's 21 days after when they're due, Your Honor.
Yes, it will be. I'll go ahead and have those order setting hearings forwarded to my queue. And just to make a reminder for ourselves, I'll go ahead and set a tickler for July the 16th, just to make sure that we've already set them for you.
Thank you, Your Honor.
July 15, and that's
No, July 16th is just a tickler reminder for me.
Oh, okay.
Yeah, so once we'll go ahead and get them set, and then you'll have your time to respond.
Okay, thank you so much, Judge. May I?
Okay.
I have another case with you, Judge.
Sure, let me see if Mr. Schroeder's done.
I'm done for today, Your Honor. May I be excused?
You certainly may.
You have a great day, Your Honor.
Likewise. Okay, Mr. Guerra, what other case do you have?
I have number 34 in your docket, Your Honor.
Okay,
This
that is set, that's set for 11. I don't know if anyone is here from the other side yet.
I don't think so, Your Honor. This is one where it's an old case, but they keep on selling the paper on my client's house, and it's been sold about 3 times. So every time that I serve someone, it's nowhere they sold that paper. We're no longer involved. So again, I served someone else, and now they told me the same thing. So the court asked me to make sure that I serve the proper party. So I'll keep on trying, Judge. If you want to maybe give me another 30 days, I'll keep on trying. These people keep selling the paper, and I keep trying to go after them.
Okay, so the latest one, then they said they're no longer in charge of the.
Right. I talked to, you have Daniel Tobin there as a defense attorney.
Okay.
And that's the last one that I talked to, and he's telling me that he's no longer, they're no longer have the interest in this property because they sold the paper. So I'll keep on following, tracking them down.
Okay.
My client is in the house and he's not paying. So if nobody's interested in trying to come after them, it's fine with me.
Okay, hold on. Okay, Ms. Rivera, where are you? What date are you seeing those judgments on?
Judge, the judgments for the defendants, North American Mortgage Company and Aurora Bank, our case notes reflect that the agreed judgment for Aurora Bank was granted by Judge Rudy on April the 8th, 2016. Then there was an agreed judgment September the 18th, 2014 on North American Mortgage Company. The North Star Mortgage, it was filed under the same case, but it was a first amended original petition and request for TRO and temporary injunction, and that was in 2018.
So, Mr. Guerra, do you have judgments on some of the defendants already?
I think so. I need to go back, but I think that Aurora or one of them had asked me that they had sold the papers. I need to go back and see.
And so you only have judgments on them because they no longer were owners of the note.
Right, and so the if any one of these people claim that they have a right to the house, believe me, they would have already. My client's been there for since 2012, and he has not made any payments, and nobody has come after him. So I don't think even the banks know who owns that house because they would have already come after him.
What about a title search? Have you done a title search?
That's a good idea, Judge. I guess I could go ahead and do that and see who's the latest one that we have. I'll get Sierra Title to help me.
Because once you do a title search and it's whatever's on the title, then that's the only thing you're going to be legally bound by.
You're right, Judge. I appreciate that. Give me 30 days. I'll make a notation. I'll get a Sierra Title that They're very good about doing me title searches and see who's the last one that owns this property.
Okay, let's come back on August the 16th at 9:30.
Thank you, Your Honor.
Okay, so let's see what you find because now I'm curious myself.
Okay, thank you, Judge.
Okay,
That's
hold
the
on.
oldest case. That's the oldest case that I have.
Yeah, my court coordinator was gonna say something. Go ahead.
Just for clarification, would that be carried over as a bench trial or a status?
No, we're gonna have to do a status because the bench trial was only for if it was the correct defendant.
Yes, ma'am.
Okay. If that's all, Mr. Guerra?
That's it, Your Honor.
Okay. Mr. Gorena?
May I
Good
be
morning,
excused?
Judge.
Good morning. Yes, Mr. Guerra, you are excused, sir.
Your Honor, I have number 4 on your civil docket.
Okay, F 1320-20-9 in the matter of the marriage of David Lopez Jr. versus Stephanie Vallejo.
Your Honor, David Gorena for David Lopez.
Good morning, Judge Savannah Gonzalez for Ms. Vallejo.
Okay, and what is the announcement, Counselor?
Your Honor, we had supplied the court with a recommendation from Gilda Bowen at the last hearing. We were pending Ms. Gonzalez's client moving down from Nueces County. She's advised me this morning that she has moved down here, but I would like some time to confirm that has happened. There's also a couple of details in the recommendation that need to be addressed regarding the child's being reevaluated because of his autism, and then also to discuss some issues regarding some speech therapy that was made as a recommendation by Ms. Bowen also. But all of these things that we're talking about are dependent on whether or not Ms. Vallejo moves down to Hidalgo County. Again, I was informed that she has, but I know that based on what my clients told me, the child has been with her for the majority of the summer, but has been in Corpus. So again, the reason for the recommendation of splitting custody was based on the fact that the mother would move down. So we just need to confirm all this information and then possibly submit an agreed divorce decree if we can do that.
Okay, and how much time do y'all need for that?
Well, Judge, what I was going to say is my client's prepared to provide that address today. I did confirm with her. The primary residence of the child was ordered to, or rather was proposed to be in Hidalgo County. She has an address where she will be residing with her mother. As far as the speech therapies and the autism evaluation, I have discussed that with her. She did try to make some appointments and dad did not comply with taking the child. So I told her to set them up again and she needs to take them on her time. The child is currently enrolled under father's healthcare plan. I do believe, Judge, that my client would likely qualify for government health benefits, which may assist with some of those costs. I have an autistic child myself, and I can tell you it's crazy expensive to run those therapies. So I'm going to have her look into that, see if in fact she can apply, maybe get some secondary coverage or see how that would work out. But for the most part, this has worked out. We just have to work out the semantics. I really don't want to let it drag on too long.
Okay, well, you all tell me when you want to come back.
Well,
How does 3 weeks look?
I don't think we need more than 30 days, Judge.
Okay. Ms. Rivera, did we open up July 21st? I don't recall.
We did, Your Honor. We do have some contested matters, but if it's approved up, I believe it should be good.
Okay, if it's agreed to, I can hear you on July 21st at 9:30.
That date's fine with me, Judge.
Likewise.
Okay, then we'll see you back here on July 21st at 9:30.
Excellent. Thank you, Judge. May I be excused?
Thank you, Judge. Thank you.
Okay, do we have anyone here on CL 192236-I TD Auto Finance versus Mutsuki Goto?
Yes, Peter Knapp for plaintiff.
Okay. And do you know if Mr. Goto was properly served? Because I have you, are you just gonna urge to keep the case on the docket?
Yes, I am.
Okay. Then we'll go ahead and grant your request to keep the case on the docket and we'll set you up for a status hearing. How much time do you need in order to give me a good status on this?
Probably, maybe most 5 or 10 minutes. This should not take long.
Okay, so you're gonna file a motion for default judgment, or what are you doing?
I believe one has already been filed.
Let me check. Okay, so you filed a motion for default judgment on June 2019, and you do have an order for that default judgment. However, you need an order setting hearing for your default judgment.
Right.
So if you'll file an order setting hearing on your default judgment and make sure you copy the defendant, and then we'll get that set for you.
Thank you, Judge.
Okay, so I'm gonna set a tickler for myself for July the 16th, just to make sure that the order setting hearing on the default judgment has been filed. Okay?
Thank you very much, Judge. That was all I
Okay.
had. May I be excused?
You certainly may.
Thank you, Judge.
Thank you. Okay, give me one moment. Okay, Ms. Portis, are you ready on yours?
Yes, Your Honor, I am.
Okay, go ahead.
I've got number 10 on the docket, actually number 9, number 10, number 11, and number 20. I guess I'll
Yes.
start with number 9. Is that okay, Judge?
Yes, CL 194274-I, One Main Financial Group et al. Versus Jose Perales. And let me have Mr. Perales's name called out 3 times, please.
Jose S. Perales, Jose Perales, Jose Perales.
Okay, the defendant's name has been called out 3 times and no response. You may proceed, Ms. Portis, on your motion for default judgment.
Yes, Your Honor. Claire Portis here on behalf of One Main Financial. We filed a motion for default judgment on May 17th of 2021. I'd asked the court to take judicial notice of all the documents in the file and the attachment to the motion for default judgment and make a ruling on that judgment today, showing this was an installment loan ending in account number 7469 that was opened on May 25th of 2017. There's a charge-off balance in the amount of $6,174.12. Suit was filed on August 13th of 2019. Defendant was served on August 26th of 2019. Defendant has neither answered or responded to our motion, so I'd ask court to grant judgment as requested.
Okay, the court will take judicial notice of all the documents on file, specifically that the defendant was properly served and did receive proper notice of the hearing for the motion for default judgment. The court will further grant the relief as requested by the plaintiff. And are you asking for the order that's on file from May 17th, 2021 to be the one signed?
Yes, Your Honor.
Okay. Then I'll have that forwarded to my queue for signature.
Thank you, Your Honor.
Okay, CL 194295-I, One Main Financial versus Joel Roque. Let me have Mr. Roque's name called out 3 times.
Yes, ma'am. Joel Roque, Joel Roque, Joel Roque.
Okay, being that the defendant's name was called out 3 times and no response, you may proceed, Ms. Portis.
Yes, Your Honor. We filed a motion for default judgment on August 19th of 2020. I'd ask the court to make a ruling on that motion and enter its attachments into evidence today, showing that there's an installment loan with One Main Financial. The defendant opened with a past due balance amount of $7,356.40 as charge-off amount. Suit was filed on August 13th of 2019. A defendant was served on August 27th of 2019. Defendant has neither answered or responded to our motion. There's a proposed order attached to our motion for default judgment. I ask the court to grant or enter that order.
Okay, the court will take judicial notice of all the documents in the court's file, specifically that the defendant was served properly and failed to answer, did not show up today, and will grant the relief as requested by the plaintiff. And the order that I have on file is the one from August 19th, 2020. Is that the one that you want signed?
Yes, Your Honor.
Okay. And that, and also will admit the exhibits as evidence. Okay, so that'll be granted. And now we're CL 195053-I, One Main Financial versus Josefina de San Martin. Mr. Damian, please call out the defendant's name 3 times.
Josefina Mendo de San Martin. Josefina de San Martin. Josefina de San Martin.
Okay, the defendant's name being called out 3 times and no response. You may proceed.
Yes, Your Honor. We filed a motion for default judgment in this matter on September 24th of 2020. We're asking for $3,576.31 cost of court and post-judgment interest as outlined in the proposed order attached to that motion. I'd ask the court to take judicial notice of the motion, enter its exhibits in as evidence, showing that there's this was an installment loan that defendant was served on November 19th of 2019 by substituted service and has not answered or responded to our motion. Again, that proposed order is attached to our motion for default judgment.
Okay, the court will take judicial notice of all the documents on the court file, specifically that the defendant was properly served and did not file an answer. Defendant's name was also called 3 times and did not appear. The court will grant the relief as requested by the plaintiff and will sign the order that's on file for September 24th, 2020. And will also admit the exhibits into evidence.
Thank you.
Okay, and then which other number was it? Number 20? Okay, CO 195075-I, One Main Financial et al. Versus Manuel Salceda Jr. Can you please call out Mr. Salceda's name 3 times?
Yes, ma'am. Manuel Salceda Jr. Manuel Salceda. Manuel Salceda.
Okay, defendant's name being called out 3 times and no response. You may proceed.
Your Honor, we filed a motion for default judgment in this matter on May 17th of 2021. This is concerning a installment loan with One Main Financial ending in account number 9889 that was opened by the defendant on April 27th of 2018. There's a charge-off balance, the amount of $18,154.78. Defendant was served on January 14th of 2020 by substituted service. There's been no response to the no answer filed or response to the motion. We'd ask the court to grant judgment as requested, also to enter into evidence all attachments to the motion for default judgment, and there is a proposed order attached to the motion.
Okay, the court will take judicial notice of all the documents in the court's file, specifically that the defendant was properly served, no answer was filed, and he did not appear today. The court will grant the relief as requested by the plaintiff. The exhibits are further hereby admitted. And I was going to tell you, Ms. Portis, that and the court will sign the order that was filed on May 17, 2021.
Thank you.
In the future, on the order setting hearings, I know I've already addressed it with the other attorney, with Ms. Jessica, when she's come. Please make sure that your staff CCs the defendant. My staff has been doing it, and we don't have time to do that. So all the order setting hearings must have all parties that are required to be at the hearing CC'd on that order setting hearing. If not, in the future, we will reject them, and it'll take longer for you to have your motion set, okay?
Thank you, Your Honor. We will do that.
Okay, so does that conclude your business before the court today?
Yes, may be excused.
Yes, you may.
Thank you.
Thank you. Mr. Denzer, what do you have?
I have number 25 on your docket, Judge.
Okay.
I raised my hand at the beginning, but I don't know if it disappeared, and I don't want to
Yeah.
interrupt.
Oh, it's okay. Don't ever worry about that, because I don't know what happens with the reaction button, because I didn't see it. And some people have been putting other reaction buttons other than the raise the hand, and those are so hard to see because they come out yellow, and so they blend in the background. And when you do the raise the hand, it automatically moves you to the top of my screen.
Okay.
And so I don't know. That's why I've been trying to tell people to do the raise your hand, but I apologize for that. Don't be afraid to interrupt. I know you guys have a lot of things going on than to be waiting for you to be called on the docket. So I see Mr. Medina is on as well. So this is CL 1902886-I, Teresa Valdez versus Jose Rodriguez.
And Nick Denzer for the defendant, Mr. Rodriguez. We filed a motion to substitute because the defendant's insurance company went out of business. So the Texas Property and Casualty Insurance Guarantee Association took over, and so the case is gonna change a little bit. But that's why I substituted in, and that motion's set for today, and we're also set for status.
Okay, and Mr. Medina, do you have any objection with Mr. Denzer substituting?
No objection, Judge. He is correct that I think we do have a new insurance company that has taken over. So as far as status goes, I think they are working on that claim. That we may not need to litigate this case, but that's the status on it right now.
Okay, then being no objection, the court will grant your motion for substitution, Mr. Denzer. And how much time do you all need now that you're in this position? Is discovery carrying over? Are you having to do new discovery, or where are you at with that?
I actually don't have all of the file materials yet, but we don't have to do new discovery. They just have to, the plaintiff would have to verify that they don't have any other insurance that would be applicable. And I think the plaintiff had the same insurance that my client had. So I think both insurance companies are out of business. So it's just a matter of just asking for documents for Mr. Medina, and then TP-SIGA will evaluate the claim and try to settle it.
Okay, and are y'all gonna agree on a mediator, or are you doing this informally?
Informally is how they prefer to do it.
Okay.
Yeah, there's new adjusters on it. So we may be able to get this thing done without further involvement from the court, but obviously we had filed previously, and then that company went out of business. So it's a unique situation that doesn't happen very often. So, but we should be able to try to get this thing done without further court involvement.
Okay, so how much time do y'all need for another status?
45 days, maybe, Judge,
Okay,
or 60, whatever's the next.
Yeah, I would say 60 days, Judge, just to give the new company a little bit more time.
okay, let's come back on August the 25th at 9:30. That's about 60 days.
All right, thank you, Judge.
Okay, sorry for the wait, gentlemen.
May we be excused?
Yes, you may.
Okay, thank you.
Okay. And I believe, so Ms. Palacios Cruz and Ms. Ramirez, you're here on CL 163265-I, No Chantu versus Kevin Ho.
Yes, Your Honor. Maria Antonia Ramirez for Movement.
Good morning, Judge Audrey Palacios Cruz on behalf of the non-movement.
Okay, and are y'all ready to proceed?
Yes, Your Honor, we are.
Okay, go ahead, Ms. Ramirez.
Thank you. I represent the defendant, Kevin Ho. And this is a suit, Your Honor, that involves the plaintiff is suing Mr. Ho, alleging that he paid $35,000 to purchase some equipment and furnishings for a restaurant. The restaurant by the name of Pho Bamboo. That restaurant is Vietnamese, and my client is Vietnamese. The plaintiff is Chinese. My client speaks very little English. In fact, all he recognizes are a couple of words. He is fluent in the Vietnamese language, and he did own some property that was in the restaurant, and he also registered the restaurant in the court records of Hidalgo County. Now, my client defendant is denying that there was ever an agreement to sell any equipment or furnishings. Also included in the suit are an agreement that he would sublease the location there on Olana. But my client is stating that he never met the plaintiff, he never spoke to him, he never received any money from him. At the central part of this case, Your Honor, are exhibits A and B that are attached to my motion. If I will refer the court to exhibit A, it's a very short little document that says, my name is NGOC and then THU. And then next to that, it says Pho Bamboo to sale, 45,000. Then it's got 3/14/16 deposit, 3,000. And then it's got some, like as if somebody put some initials there. Then it's got a new balance of 42,000. And then the initials, 2,000. And then they subtract it and leave 40,000. That was exhibit A. Exhibit B contains some strange words, which I really don't know what language that would be in, Your Honor, but it says Chi, CHI, THU, DAI. I still don't know what that means, but it's got 5,000, then a date, 4/14/16, then some initials, then 25,000, a date, 4/15/16, and then some initials. Now, this is what is the basis of the agreement that the plaintiff is trying to seek the money from the defendant. I also, Your Honor, have as exhibits attached some responses from the plaintiff to request for admissions. And the ones that I direct the court to, it's got 16 different admissions, but I direct the court to number 4, where it says, admit or deny that your name, that's Mr. Chantu, that your name is not on exhibit A. And he says, admit. Then we go to 7. It says, admit or deny that exhibits A and B are the only written evidence of your agreement on which you are suing the defendant. And the answer is admit. Therefore, he's relying on A and B, which I went through a minute ago. On number 8, admit or deny that the specific details of the agreement that you buy what you allege defendant sold you are verbal. And the answer is deny. Then I go to admission number 12. Admit or deny that the defendant's signature is not on Exhibit A. Admit. Then I go into Exhibits 14 and 15, which says admit or deny you did not prepare Exhibit A. Deny, which means that he did prepare it. Admit or deny that you did not prepare Exhibit B, and he denies it, which would indicate that he did prepare it. So, Your Honor, that is the basis of what the reliance is on alleging that defendant sold equipment and furnishings for a Vietnamese restaurant to the plaintiff and to sublease where he was leasing himself at the time. In the law, Your Honor, when we go on a motion for summary judgment, there can be no genuine issue of a material fact. I am relying on the fact that the court is the determiner of the validity of the contract and the enforceability of the contract. There is no description of any equipment in Exhibits A and B. There are no names of buyer or seller. There's nothing referenced as far as agreeing to sublease. In the law, Your Honor, you do have to have an offer and an acceptance. You have to have the meeting of the minds of the parties' consent, execution, and delivery of the contract. In this case, Exhibits A and B are vague. It doesn't really say, it just has amounts of money. It's got initials there, which I could not really understand them. And there is no evidence to identify those initials. There's no mention of any sublease. In the Texas Business and Commerce Code, Chapter 2 defines what goods are. This is a sale of goods that plaintiff is bringing a suit against defendant. Goods are defined as things that are identifiable and movable. If the sale was of the furnishings and things like that, they would be considered goods. And under Chapter 2.201, it says that a contract of $500 or more to be enforceable must be in writing sufficient to indicate that there has been a contract made. So we're using this, Your Honor, as the law that the plaintiff doesn't have that in this situation. It's got no contract because it's lacking all of this. If it is oral, well, it would already have violated provision 2.201. Another cause of action that the plaintiff has filed against the defendant is for fraud. And the fraud is alleged to be because of false representations that were made allegedly by the defendant. The defendant's representations, as alleged in the amended petition, says that they deal with subleasing the place, but there are no details or anything. There's no mention of that, and to sell the equipment or the furnishings that are the main goods involved in this case. There was no contract. There cannot be any representations made to sell when there was no agreement, no offer, no consent. There is no issue as to the fact that there is nothing else. in admission number 7, it says, admit or deny that this is the only written evidence of your agreement on which you are suing, and that is admitted. So there's nothing else out there, Your Honor. My client's name is not there. My client has also executed a affidavit as an exhibit, and has stated that he never received any money. He never made any agreement. He never spoke to the plaintiff. In the petition, the plaintiff is saying that he did give money, but it was to the sister, to the defendant's sister. But other than that, it's just an allegation.
Okay, Ms. Ortiz, how much time do you still need?
I need a little bit.
Okay.
Your Honor, at this time, I would like to have my exhibits admitted into evidence, and just would like to summarize that this is a legal issue, that there is no cause of action against the defendants. I'll pass.
Okay. Okay, you haven't offered them yet as to evidence, and so if you want me to do a share
Yes,
screen,
I would like to offer them.
okay.
As
But
a
I do
exhibit.
need to take a 5-minute break. Okay, so we will, while you're getting your exhibits together and ready for the share screen, we will be off the record for 5 minutes. Okay, we're back on the record. Before we continue on this case, let me quickly call F 4672-19-9 in the matter of the marriage of Michelle Zamora and Rolando Zamora.
Your Honor, I'm here. This is Michelle Zamora.
Yes, ma'am. Okay, so I did see that the divorce was already granted. However, the issue was in the wording of the divorce decree.
Correct.
And so has an updated decree been filed?
Yes, it has.
Okay. Give me one moment.
Yes, ma'am.
Okay, so the last decree that I have from the court that was tendered to the court was filed last year.
And I have since submitted one, Your Honor,
Do
to
you
your
know
court.
what date you filed it with? What date you filed it?
I can give you that if you give me just one moment.
Sure.
Judge, it was filed June the 22nd of 2021.
Right, that was the one that's the updated one, because the other one was filed June 24th of 2020. So the one sent to you, to your docket on 6/22 of 2021 is the updated one with the corrections that I was asked to make.
Okay, so June 22nd, 2021. Okay, I'm not seeing the Miss Rivera, which is the one that's, are you seeing on our side that has it? Because the one that I'm looking at that says decree returned by the court, that one still didn't have the percentages on the exhibit.
Okay, Judge, I believe it says motions petitioner to set hearing. And then above that, there was one that was filed 2021. There's two petitioners. There's two final decrees of divorce. They were both filed.
Okay. So on 6/15/2021 was the one that we're looking at?
Yes, ma'am, they would have been the same.
Okay. That one states that you were not present at the hearing, but you were present. Is that correct?
That is correct. We were both present, Your Honor.
So then we'll just cross that out. And then the issue was, has the residence already been sold?
We have already executed that as of last week per the decree as it was stated.
Okay. So this
that was followed.
Okay, this is what we're gonna do because it's still not correct. There's certain language that needs to be there. However, I do notice that your husband is on. So I just need to, Mr. Zamora, can you hear me?
Yes, I can.
Okay, sir. Then I'm just gonna ask you to raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God, sir?
Yes, I do.
Okay, sir. Just for clarification and so that I can sign a divorce decree today and have have this matter concluded for you. I just want for you to put on the record the divorce decree that has your signature on it. Those are the terms that you're asking the court to accept today, sir.
That is correct.
Okay. And so, and currently you understand the terms with respect to the sale of the home. Is that correct?
Yes, I do.
And you understand and you are in agreement with the division and the instruction as to how to divide the net sales proceeds. Is that correct?
Yes, that is correct.
Okay. And are you in agreement with the remaining terms that are set forth in Exhibit A of your divorce decree?
Yes.
Okay. Then what I will do is, now that it is on the record, I'm not going to have you update it again because then it's only going to prolong the matter. I will sign the divorce decree that was filed on June 15th, 2021 at 12:59 p.m. That's the one that I'll ask to be forwarded to my queue. And the only correction I'm going to make, Ms. Zamora, is just to change it from that you were not present to you were present.
Yes, ma'am.
Okay.
Yes, Your Honor. Thank you.
And just to clarify, are you requesting a name change at this time, ma'am?
No, I am not, Your Honor.
Okay, then the court will approve the terms that were set forth in divorce decree filed by the party. And that'll be the one that I sign, and it should be sent to my queue today, and I'll sign off on it as soon as I get it.
It is greatly appreciated, Your Honor.
Okay, you're very welcome. Y'all have a great day and best of luck to you all.
Thank you, ma'am. Likewise.
Okay.
Thank you.
Okay, Ms. Ramirez, were you needing to meet for me to, we're back on the record?
Yes, Your Honor.
Let me get that case number real quick. On CL 163265-I. And then in order for you, I'll do the share screen so that you can introduce the exhibits. Okay, you're able to share now. If you can prove up.
I don't really see that on my computer, Your Honor.
If you're gonna share a document, it should give you, I've changed the feature so that you can share share the exhibit on there.
Judge, we're happy to reset the hearing so that Ms. Ramirez can work out the share screen function.
Okay.
I do have my response on file already with the court, so we wouldn't be doing any more work on this motion. We would just need a hearing, I would say the week of, the second week of July.
Okay, Ms. Ramirez.
Yes, Your Honor.
Okay, so what I can do is I can reset you to continue the hearing on July the 7th at 11 a.m.
All right.
Your Honor, I apologize, Your Honor, I'm going to be out of town. I won't return until that next week.
Okay, let me do.
I can't do it either, Your Honor.
Oh, Judge, I do apologize. I will be here that day. If the court is available and Mr. Ramirez is available.
On July 7th, I'm not available.
Okay, how about the 20? I have a lot on the 21st, but I can squeeze you in to finish at 11.
Yes,
July 21st.
at 11.
Okay.
Thank you,
And then,
Judge.
yes, and then that way you can do the share screen and share your exhibits, and then we'll go ahead and take it up at that time.
All right, Your Honor, thank you so much.
Okay.
Thank you, Judge, if I may be excused.
Yes, you certainly may.
Thank you, Your Honor.
Yes. Okay, so I have Melinda Aleman and let me see. Okay. So CL 211946-I, Melinda Aleman versus Marisela Rubalcaba.
Yes.
Okay, Miss Aleman, and do you see Miss Rubalcaba on?
No.
Okay, let me see. Mr. Damon, can you please call Marisela Rubalcaba's name out 3 times?
Yes, ma'am. Marisela Rubalcaba. Marisela Rubalcaba. Marisela Rubalcaba.
Okay, the defendant's name is being called out 3 times. This is an appeal from the Justice of the Peace. Out of Precinct 3, Place 2, with the former cause number of LT 21-0159-J32. Ms. Aleman, the issue that I see is that Ms. Rubalcaba was not given notice of today's hearing, ma'am. The only
She told me yesterday that it was fraud. Because I don't know. She said it was fraud what we were doing because it was gonna be through Zoom. So I was like, I don't know why they. Well, probably because of the COVID, right?
Yeah.
And she said she wasn't gonna get on it. So I don't know what.
Okay, let me I stand corrected. The order that was sent out by my office was sent out to both you and Ms. Rubalcaba.
Yes, because she did tell me that. What she said that the Zoom was fraud because how come she wasn't gonna go to court or something like that. So I told her, well, I have it through online too, so I don't know what you're talking about.
Okay, so Ms. Aleman, what is the relief that you're asking from the court today, ma'am?
Well, I just want her to get out of the lot because I have 3 years here paying the lot, and I've been struggling a lot because they don't want to work and they don't like her and her son. She has a son in her home. They don't want to work and they don't want to do anything. And they told me that, when we signed the papers, she said that to give her time to move out. But it's been already 3 years, almost going to go to 4. And she's always, every year she's telling me that they can't work because they have a depression or something like that. But the thing I don't want them here is that I ask them to pay the light, like, because we have to pay half and half. And she's always telling me that she doesn't have money and this and that. So she's always giving me excuses, and I cannot be struggling because I have a job and I only get paid $200 every 2 weeks. And I have 4 children, and the son, he smokes weed, and I already went to the court here in Mission to tell him that they had plants, but they said that they couldn't do anything. So I told her to take off those plants because they were weed plants. And every day is like, they have a lot of cars here because the son, he brings all the friends over here. They party every day. And I have my kids, and I can't even let them go out because it's full of cars here in the lot. I'm scared that they're going to run them over or something. And then they're always smoking weed outside. So I just.
So in the judgment in the eviction case in the lower court, you were granted possession of the premises and she was ordered to vacate the property within 5 days. Is that correct?
Yes.
Okay. Then, being that she failed to perfect her appeal and failed to show today, the court is going to uphold the judgment from the lower court. And so she will have 5 days from today's date to move. And once she hasn't, then you can proceed forward with legal action if you need to, as far as getting the police involved in things. Okay. So her appeal will be denied and your judgment will stand from the lower court.
Okay, thank you very much.
Okay, ma'am.
Your Honor,
Yes.
I don't see any order to that effect.
Who's the judgment?
The order for this case, Your Honor.
Oh yeah, she has to file an order. Well, actually, it's Miss Alem. If she chooses to file an order, she can. If not, she's going to use the order that was signed by Judge Peña, because that judgment is going to stand.
Yes, ma'am, but the clerks would have to have an order to dispose of this case. So I'm not sure.
We would file the order denying.
Okay.
Yeah, we would follow the order denying the notice of appeal. Okay.
So do I have to go to, sorry.
You'll receive an order in the mail. They should mail it to you.
Oh, okay. Okay, thank you very much.
Okay, well, good luck getting her out. Because it's just, you know what I mean? Like, you're going to still struggle. Just because you have a piece of paper doesn't mean that she's going to get out. You're going to need to stay on top of it.
Mm-hmm. Okay.
Okay, so best of luck to you, Miss Alema.
Thank you.
Okay, you take care.
Likewise.
Okay, thank you. Okay, so Miss Span, I have you as Rita Span. What case are you here on?
Do you need the case number or
yes,
the division? I just had it. It is CL 210469.
Okay, I have Discover Bank versus Rita Span. Is anyone here on behalf of Discover Bank? Okay, this was a hearing on a motion for summary judgment. Is that correct?
Yes, ma'am.
Okay.
I got a letter from AmeriCorps. If you don't mind, I can read it to you.
Well, it probably won't be necessary, being that they're not here to urge their motion.
Okay.
So give me one moment. Okay, Mr. Damian, can you please call out Discover Bank 3 times?
Discover Bank, Discover Bank, Discover Bank.
Okay, nobody appearing on behalf of Discover Bank. The court will take judicial notice of all the documents on the court's file, specifically the notice of filing that was sent, that was the title that plaintiff gave it, notice of oral hearing. It was filed on May 24, 2021, and it was a notice sent by plaintiff to Ms. Span as a defendant of a hearing today on their motion for summary judgment. Being that no one is here to urge that motion is denied. Ms. Span, you would need to file an order denying the motion for summary judgment. And I would get that filed as soon as possible.
Okay, and how do I go about doing that? I'm sorry.
Unfortunately, I can't tell you that, ma'am, because you're representing yourself.
Okay,
but
so
you have a law library
uh-huh.
that you are allowed to use. I think they're open.
Okay, can you repeat what I need to file again?
Order denying plaintiff's motion for summary judgment.
Okay.
Okay,
We'll go ahead and take care of that. Thank you
Okay.
very much. Appreciate it.
you're welcome. Okay, Ms. Richardson and Mr. Brunetta, I do have one more case that I need to take care of before we get to you. So just please hang tight.
Yes, Judge, I'm on standby.
Okay.
Thank you.
Mr.
Likewise, Judge.
Davis and Mr. Ball.
Yes, ma'am.
Okay, I'm gonna recall F 4121-19-9 in the matter of the marriage of Gabriela Flores versus Ramon Flores. Okay, so the court has read the briefs as submitted by the petitioners and the respondents, and that there are a couple of questions that I have with respect to just clarifying points. And it's up to the attorneys whether you all want to answer the question for me or if you want your clients to answer the questions for me. But I understand that the last thing that is to be divided before we can move forward with the final hearing is the characterization of the marital residence. And that marital residence was acquired by Mr. Flores and because of his disability with when he was in the armed forces. So I did see the deed. Now, first, before we move on, is there any objection to the deed that was presented as an exhibit by Mr. Ball, Mr. Davis?
No, there's no objection to it, Judge, but if the court will note, it's not a gift deed. It's a general warranty deed.
So noted. And Mr. Ball, being that there is no objection, then I'm taking that into consideration. So
May I ask that the deed be admitted into evidence? And then there's also an affidavit that was attached by my client. I'd ask that the affidavit be admitted just for purposes of this hearing, Judge.
okay, so I did have an opportunity to also review the affidavit. Mr. Davis, I know you didn't have an objection to the deed. Do you have an objection to the affidavit?
Well, not for purposes of this hearing, Judge.
I understand. Okay, being that there are no objections by petitioner's attorney, then both the deed and the affidavit will be admitted into evidence. So my question is, I know that you said, Mr. Davis, that it's not a gift deed, but I did see where the language on the deed states that it is being given as part of a gift or a contribution to Mr. Flores. How do you get past that, Mr. Davis?
We get past it because in order for something to be a gift, that gift has to be immediate, with an unconditional divestiture of the interest in the property. And there has to be no conditions as to the gift itself. And that's just not the case here before us, because my client was required to execute an agreement. She was required to be responsible, along with her husband, for payment, for upkeep of the house, for all these things. And it was only after they were supposed to have done it for at least a year. It went on longer than that. It was only after that the property was actually transferred. Now, I suspect the reason for that language in the general warranty deed is for tax purposes, so that the company or the charitable organization has that on file for tax purposes, showing that they didn't receive any actual cash for the property. But again, there's a way you can do this when you have a married couple and you want to give, have an agreement that I'm going to give him something, but it's going to be only his separate property. They could have entered into a separate property agreement. They could have done a post-nuptial agreement just for purposes of this transaction. There's a lot of things that could have been done. Obviously, that wasn't the concern of the homes for the home front. They required my client to be a party to the transaction, to sign off on the agreement, and to be responsible for everything. So, under the inception of title rule, if we go back, under looking at deciding whether things are community property or separate property. It was obviously acquired during the marriage. And it's incumbent upon Mr. Flores Mr. Flores to show that it was a gift. And I just don't think that's there because of the background as to how they actually acquired this property. It wasn't like somebody just came by one day and said, "Hello, sir, I heard you were a wounded veteran and I want to give you this car. I want to give you a house. Here it is." They had to go through a process before that could happen. And my client was an equal part of that process.
Okay, Mr. Ball, do you want to respond?
Yes, Judge, that I'm not aware of any case law that says if there is a process that it somehow changes the characterization of what's on the deed. Of course, there's going to be a process. We're taking real estate that was being held by a charitable organization and is being gifted to an individual, and it's tantamount to it's something that he is receiving based on his time, his service in the military and being a wounded vet. It would be, I guess, the same way that folks, when they receive payouts for injuries in personal injury cases, it's for their personal injuries, and that is a separate property. In the same way that any of his disability that he receives from the VA, that's personal to his injuries. It's personal to himself. It's his separate property. And here, whether there was a process or not, and there has to be a process to transfer stuff. That's just the nature of our practice. It still doesn't change that it was a gift to him. I agree with the inception of title rule, but the case law, as I see it, is pretty clear that when the deed, number one, says it's a gift, number two, he accepted it as a gift, number three, he has testified per his affidavit that it was a gift. All of that turns it into a gift, and there is nothing that says on top of that wife has to execute a post agreement or has to execute any particular form. There is no magic language, to borrow from the Supreme Court. There's no magic language for what makes a gift. That it's the intent that's reflected on the face of the deed. It's the intent that my client testified to via the affidavit, and so we respectfully request that the court find it as his separate property. And with that, I'll close. Thank you.
Okay, so who's responsible for the property taxes?
Mr. Flores, can you address that?
I am, Judge.
Okay, and was there a document that Ms. Flores executed stating that she was equally responsible for property taxes?
Yes, ma'am. And Judge, that was attached to mine as Exhibit 1.
Okay.
And I would ask that that be admitted.
Okay, any objection, Mr. Ball?
No.
Okay, I did see it. Okay, and what about the homeowner's insurance?
They were responsible for making essentially a monthly payment that covered those things. And it was supposed to be for a year, and for whatever reason, it went beyond that, probably because of this pending divorce.
Okay, and so how does Mr. Flores get past the fact that their community property funds were used to pay for the property taxes and the homeowner's insurance?
That happens all the time. People live in separate property homes. Married couples live in separate property homes, and community funds are expended on taxes. They're expended on upkeep. They're expended on things like insurance. And so the remedy for that is not changing the characterization of the property, and it does not change the characterization of the property as a gift. Instead, what that does is it could potentially, if it's pled for and proven, entitle Ms. Flores to receive some sort of compensation in the form of reimbursement for community funds expended if they consider that to be the improvement of separate property. However, there is no evidence they put forward that it was an improvement to separate property, and she would still be required to show that she received or that they invested more than I'm sorry, that they increased the value of the property, and she also received the benefit of those community expenditures by living in that house. So it doesn't change the characterization of what's on the title, doesn't change the characterization that it was a gift, but it could entitle her to some amount of funds to be given back to her community.
And the issue was that at that time, it was not either community property or separate property, because there hadn't been a transfer. But when we talk about the process, Exhibit 1 is what shows the process. In order for us to end up where we are now with the property being deeded to Mr. Flores, both of them had to agree and were bound by that agreement in order for the property to end up being deeded.
And that's fine. And that's just more evidence of the fact that she knew what she was getting into when she signed off on all of this. They knew that they were getting into a charitable organization that was going to gift property to Mr. Flores on account of his being a wounded veteran. So if it wasn't even their property, it wasn't community, it wasn't a community home to begin with. And neither he nor her would be entitled to any reimbursement for the funds that were put into it. And the fact that it was still deeded to him and she was a participant in that process, I understand it's a tough pill to swallow. I get it. And I've been on the other side of it with clients, but it just doesn't change the characterization, Judge. It just doesn't. And so that's the process doesn't change what the deed was and what the intent of the parties were. And there is no evidence.
I disagree, because in order for something to be a gift, like I said, and like I've stated in my brief, it has to be an unconditional gift. This, whatever this transaction was, it was certainly contained a lot of conditions. And they had to go through that 12-month process, make those payments, keep the house, all that. Those were all conditions.
Okay, so I've looked up and done some research of my own on the homes given by Operation Homefront. And I do see that it states that, it's 1 to 2 years of mortgage-free housing assistance, that they offer counseling to reduce debt and build savings. Now, did they both go to the financial counselings, or better yet, did they receive any of the financial counselings that were supposed to be given by that program?
Yes.
They both went to it?
Well, my client did. I'm not sure about Mr. Flores.
Okay.
And was it indicated at that financial counseling that this was going to be given as a gift at no cost?
What I'm seeing is that they have to participate as part of like the deal, quote unquote. In order, it's considered a program, and they have to successfully complete the program. And once they successfully complete the program, as stated by Operation Homefront, then they'll receive the deed to the home, and it's considered mortgage free. Is this home up for sale right now?
No.
Mr. Flores, is this home up for sale?
No, ma'am.
Why is Zillow showing it as being up for sale?
I am not aware. I live at the home. I have never put it up for sale.
Okay, so you haven't met with a realtor to sell the home?
No, ma'am.
Okay. I'm going to let you all know that I have inquired from the director out of San Antonio for the Operation Homefront, because this is very serious with respect to the home. So I'm not comfortable in making a decision, even though I've researched it myself. And I need to speak to this person in order for me to make a decision. And I don't know if you all have an objection to me doing that, or if you, I guess I'll ask you, do you have an objection to me having a phone conference with Operation Homefront, Mr. Davis?
No, I don't. I do not.
Mr. Ball?
I have no objections, Judge. More information is always good.
Mr. and Mrs. Flores, just so you all know, I'm going to be having a phone conference with them. So I don't know if they'll be getting back to me as soon as possible. But what I'm going to do is I'm going to set a tickler. I don't want to reset you just yet because it's going to depend on what they tell me. So I'm going to see if they call me within the next just week. I'm going to set a tickler for myself for July the 9th to see if they've contacted me, and then my office will contact both attorneys so that we can get you back into court, because you all need to be able to move on. However, because you've been able to agree on everything else except for this, obviously you can't move on at this time. And this is huge, and the characterization of the property, it's up to me to decide. So I'm going to be making that decision as soon as I feel that I'm completely informed. Okay. Okay. So I needed some clarification. Your attorneys have provided it to me. And so I should be able to conclude this as soon as I just have that telephonic conference for myself. Okay.
Very well.
Okay. Then I appreciate your patience and your time being on here. And we'll get in touch with you shortly.
Thank you, Judge.
Thank
you. Appreciate it.
Yes, you may be excused.
Good morning, Your Honor.
Yes,
Good
okay.
morning.
Yes, sir. Yes, sir.
Yes, I've been calling your office. We got on at 9:50. We just want to know if we've been called or not. On the docket, we're number 16, CL 21-2070-I.
Okay. No, you have not been called yet.
Okay.
So what is your name, sir?
My name is Gilberto Hasso. I'm calling on behalf of Stephanie Benavides. She's right here.
I'm right here.
Okay. So yes, I did see Ms. Benavides on. Do we have Jesusa Perez on? Okay, CL 21-2070-I. And this is Jesusa and Perez versus Stephanie Benavides. Ms. Benavides, you filed a notice of appeal, ma'am?
Yes, ma'am.
Okay. Let me just look it up. Okay, ma'am, as far as you know, Ms. Perez still lives at 2320 Swallow Avenue in McAllen?
I believe so, Your Honor.
Okay, that's where the notice was mailed to. And you're appealing a decision today from Precinct 1, Place 1, is that correct?
Yes, ma'am.
Okay, and in the lower court, was it ordered for you to remove yourself from the property?
Correct.
Okay.
I don't believe I was given an opportunity to present all of the documents that I have presented to you, Your Honor.
Okay, so then she claimed that you owed rent from February through May 2021 in the amount of $3,000.
That's correct.
Are you denying that?
I'm not denying it, Your Honor. We had, that was at the beginning of all this H1N1. My children were home. We didn't have, my fiance is stuck, his account is frozen by Hidalgo County. So we were hoping that would be done. I have also applied for assistance from different places. And I believe I turned that in to show that it just got approved. I want to say the day of that court, the first court, it was approved from the crime victims organization.
Okay, let me ask you, how much rent are you still pending?
I still have not paid. I haven't even gotten a check from them for help. It is for assistance.
Well, to be honest with you, the only thing that's saving you today, ma'am, is that Miss Bettis didn't show up to defend the appeal. But you're asking an appeal for what remedy? Like, what are you hoping to do? Because you can't stay there.
No, of course not. And if she were there, I want to thank her actually, because at the moment that I needed this home, she really did help me. And my intentions are to pay her. I am going to pay her, regardless of what was going to be the outcome. But at least 30 days, Your Honor.
Okay, well, because she didn't show up, I'm gonna grant your appeal. However, it doesn't mean that the lower court isn't going to order you to make a payment at certain time or evict you again. But the appeal will be granted, so you'll go back into to talk to the JP and see where you go from there. Okay.
Okay.
Now, I'm not going to make a ruling as to what you're going to be doing for the rent. I would just suggest that you pay her something, or if she accepts payment, as soon as possible.
Okay. Yes, ma'am.
Okay.
Okay.
All right. Well, I would say file an order granting, but it just may be faster for us to file an order granting ourselves. So we'll try to get that done as soon as possible.
Okay. Thank you.
Okay. You're excused.
Thank you, Your Honor.
Okay, so then we're back on F3270-12-9. Okay, so Ms. Ortiz, you're representing yourself, is that correct?
Yes, Your Honor.
Okay, and Mr. Aviles, is he in your office, Mr. Prunella?
He's right here next to me, Your Honor.
Okay, and the child is next to you as well?
Yes, she can be seen on the screen.
Okay, and you said that she's gonna be 16
in about 8 days. In about 8 days, Judge.
Okay, so Ms. Ortiz, before we get into, you had an opportunity to hear Ms. Richardson, who is the ad litem and representing your daughter and her best interest. So are you objecting to Mr. Aviles having custody and possession of your daughter at this time?
Yes, Your Honor. And if I can have some minutes of your time to explain myself, to explain what's really going on in my point of view.
Okay. Hold on. Before we get to that, there's just certain little things I need to jump over before we get to that. Okay, so you're objecting to Mr. Aviles having custody and possession of the child. Is that correct?
Yes, Your Honor.
Okay. So currently, Ms. Richardson, is your client currently residing with Mr. Aviles?
She is, Judge, as per prior orders.
Okay, and that was my question. So do we have temporary orders in this matter, or what orders are we operating under?
There were orders rendered by the court. As the court knows, we have a pro se litigant. And so I apologize. I don't know if those were actually reduced to writing and executed. Mr. Pruneda was charged with drafting those, but this is a highly contentious matter as between the adult parties, Your Honor. But I can represent to the court that after argument by the adult parents, the current arrangement that also included orders for counseling were rendered by the prior court, the transferring court.
Okay, Ms. Ortiz, are you currently back residing in Hidalgo County, ma'am?
No, ma'am. I'm actually in Mexico again.
Okay, so you're residing in Mexico, in the across the border, the country Mexico, correct?
Right.
Okay. And so do you have any other children, ma'am?
Yes, I have an older son, he's 18, and my other son, he's 17. He's actually under my son, my older son custody, and my mom's also taking care of my son.
So
He's 17.
let me ask you, since you're residing currently in another country, why are you objecting to Mr. Avila's having possession of your daughter at this time?
Because this started, we've been going to court for over a year, and all of a sudden, I don't have nothing personal against my daughter. I always believed and I know that we have a really tight bond. This all started when she went to visit her father. A big commotion started. I called her and she tells me, no, I have to ask my dad if I go see you. I'm like, why do you have to ask your dad to come and see me if I have full custody, if I'm the custodial parent? So when I see my daughter change her attitude towards me, that's when I reacted. And I did get mad, I did get angry, I did argue with her. We did went off on each other. That's when I called the cops on her. I told her, the cops came out. The cops said that I'm the custodial parent. She needs to listen to me. She's under my roof, under my rules, and I made the decisions. So when she was not happy with that, she tells the judge, the police, that she's gonna cut herself. So she was transferred to the behavior center. She was sectioned. Prior to this, she was with her dad 3 weeks. In 3 weeks, my daughter changed completely. Completely, she changed. When we went to see Dr. Villanueva, it came out that her father did talk negative things about me. They show her things that he had no right to do, because arguments between adults, kids are not allowed to see that. He showed records, he showed recordings, he showed that against my daughter. My daughter, she's angry at me. She's mad at me. I understand her. But that anger and that hate that she has towards me, it came from her father. He had no right to show that to her. Regardless if he likes it or not, I'm still her mom.
Okay, let me stop you right there.
Yes, ma'am.
Let me stop you. You're right. You are her mom. But right now it seems that your priorities are in a different place. And that's fine.
No, ma'am.
Let me tell you.
No, ma'am.
Do you plan, let me ask you, do you plan to come back into the United States?
Yes, ma'am, I plan. This is what is going on. October 24th of 2020, we went to court with court number 1. The judge ordered therapy with Dr. Villanueva. He did not say that I had to pay anything. We had all the month of November, all the month of November, all the month of October, and all the month of January to go see Dr. Villanueva, to at least have 3, 4, 5 sections. I have my bus ticket right here. I left Mission January 29th. We had the status January 15th. On January 4th, I called the court to get the Zoom ID number. When I called the court told me that because of their different courts and changing cases, it was moved to a different court. It was moved to court 9. Now, I called Dr. Richardson's office and I let her know that we didn't have court. So she called the court and she confirmed that the court was canceled due of the changes in court, not due because I left. I did not leave and I left it just like that. I left after supposedly we had the status check on the 15th. Now,
Okay,
my husband got released on January 28th due to legal immigrations. Yes, ma'am.
Ms. Ortiz, hold on. My question is, do you plan on returning to the United States? It's yes or no.
Yes, ma'am. I cannot tell you when.
And Your Honor, if I may, I would ask that the parties be sworn. Judge, I don't
Yeah,
know if they have.
I
been.
agree. I agree on that.
Well, I haven't taken what she's, I've just been taking.
I know, Judge, but as you can see, this case is quite contentious and all protections and protocol, I think, are in order simply certainly in my client's interest going forward.
Okay, are you gonna have your client testify if necessary?
If necessary, Judge, only if necessary.
Well, let me have the child, Ms. Ortiz, and Mr. Aviles raise their right hand.
Okay, let's see, here's Mr. Levante la mano derecha. Mr. Aviles needs an interpreter, Your Honor.
Okay, I do have my translator on. Okay, do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Ortiz?
Mr. Áviles, ¿jura que lo que va a testificar es la verdad, nada más que la verdad y toda la verdad?
Juro.
Lo juro, I swear.
Okay, and Ms. Ortiz?
I swear, ma'am.
Okay, and Ms. Aviles, the child?
Yes, Your Honor.
Okay, so Ms. Ortiz, my question was whether or not you were returning to the United States, and you said yes. And however,
yes,
you state that you did not know when. Correct?
I do not know when. As my husband, he's going through that process. And Your Honor, it's really, really difficult to get through because prior to today, there are a lot of court orders that the other court did order and it hasn't been, and it's really sad. I understand the legal issues or the legal proceedings, but we're dealing with the child. This is what we're showing a child, not to obey laws, not to obey what a judge said. The prior judge already said to go to therapy, and it hasn't been done. And it shouldn't be on my side. It shouldn't fall on me because I've been waiting on them. And if it's coming through the thing that I'm out of the country, everything is going through Zoom. We can find a doctor that takes Zoom. She has state Medicaid. We can find a doctor. That's a point. Another point. She's been on taking medication for depression.
Wait. Okay, just hold on. Yeah. We're here because obviously there's a concern with your daughter, but I'm not seeing any way of how I cannot accept the ad litem's recommendation. I know you're objecting, but where do you, I do not see your daughter living with you in Mexico, and you're not going to be coming here anytime soon due to your husband's immigration status is what you're telling me. So I'm hearing you, and obviously there's orders that may have been put in place prior to, but I also take the word of Mr. Pruneda and Ms. Richardson as officers of the court. So at this time, you're not able to visit with your daughter because you're in Mexico, and that's fine. That's a decision that you've made, and you're absolutely right. She is a child. And so regardless of whether she will be 16 and 8 days, she's still a child. And so as a child, she has representation by her attorney who is telling me there's an issue here that needs to be addressed. And so we are addressing it because as an ad litem, she has to advocate for her client who is the child. And earlier, I did hear the concern in her voice for your daughter. And your daughter is my number one priority. And this case will not be dragging on anymore because I don't think you're going to be making any changes in the immediate future that are going to change where your daughter lives. And you know what is very sad to me? Not the fact that she's being shown perhaps that the judge's orders are not being followed by the attorney. What is sad to me is that she's even on this Zoom at all. Look at her. She is emotional. She is crying. She is seeing her parents fight. That is sad to me. What is sad
Exactly, ma'am, and you're right.
Stop. What is sad to me is also that you're making decisions in your life that are obviously good for you at this moment. But if you're making those decisions, then I'm going to make some decisions that are good for your daughter. So at this time, I'm going to allow Ms. Richardson to put forth her proposed visitation and temporary orders and conservatorship to writing. Mr. Prunella, if you're in agreement, you can sign off on them, and
All
I'm
right,
going to review them. And that is going to be the order of the court, because I feel that the one at this time in the best position to see things clearly for the child is Ms. Richardson. And Ms. Richardson, I know, will have your child's best interest in mind. So she will draft the orders or give the direction as to the orders, and I will sign off on those orders. Because at this point, I fully have faith and trust in Ms. Richardson that she's the only one that is able to decide what is in Ms. Avilas's best interest at this point. You're not here. So as long as you're not here, in my opinion, you don't have a say-so as to her visitation, with or without her father being in her picture. When you come back into the United States and you want to stay here permanently, then you are welcome to change the order. But at this time, I don't care if this is by Zoom. You want to FaceTime your daughter? That's fine. You can FaceTime your daughter because you are her
She
mother.
hasn't.
Actually,
she hasn't.
Okay.
She hasn't. We do have orders to do it twice a day, and she hasn't.
Okay, to me, twice a day is excessive. So, Ms. Richardson, you were saying as to the
Yes,
face?
I'm sorry, Your Honor, if I may, I apologize for interrupting, but part of what I anticipate being included for your consideration and signature, Your Honor, is that, this is so difficult, until the situation is such that it lends itself to meaningful counseling, to where my client is in a more secure and comfortable position to engage in communication with her mother. I will be including an item that, at least for the time being, there not be communication that's attempted by mom if my client feels inclined to engage in that communication, that she be allowed to, not be refrained from or prohibited from doing that. But given the current circumstances, Judge, I would like, and I trust my client's judgment to decide whether she can engage in that communication, at least for the time being. The family code, has an overall mission to unite families and reunite them if they are in fact fractured and suffering from discord. The fact is that we are here at this point, and I believe that it is harmful to my client to continue engaging with the status quo, and that includes FaceTime communication, which is the only communication available given Ms. Ortiz's chosen living situation. I would ask that if the court would indulge that request orally at this time, just so Ms. Ortiz understands. There are times that there are very tense communications that are repeated attempts and so forth, that my client has to somehow referee on her own. And I think that serves as a major disruption to her daily life and existence. And just for your honor's good conscience, neither one of them are perfect, Judge, as in any case, right? Mr. Aviles did make accommodations and did supply my client with the necessary technological tools to continue school that he did not have before. And so the environment has been made such that she's been able to continue with as much of a scholastically normal and otherwise normal life, at least for the time being, but for the discord that exists right now between mom and daughter that I'm sure can be addressed at the appropriate time in the appropriate manner.
Okay.
If I may, Your Honor,
Yeah.
if I may add,
Hold on,
I
Mr. Viola. I was
totally,
is she going to be attending? Are you going to move forward with the counseling?
oh, Your Honor, let me address that. Ms. Poirier Aviles has already gone through counseling. Her mother doesn't know about that because she hadn't really been around. But Ms. Aviles has gone. She's willing to engage in additional counseling if necessary. And for Ms. Vanessa Ortiz to say that Ms. Poirier and Mr. Aviles have never gone to counseling, that's just not true, Judge. And there's a record. We can produce that record. And secondly, Judge, I concur with all of Ms. Reggie Richardson's comments and recommendations to Your Honor, because they are factually based. And I think that this has been a very emotional roller coaster for my Mr. Aviles' daughter, Ms. Poirier. She's a very bright young girl, Judge. She's very dedicated to her school. She has attained a very close bond between her father and herself. She has learned that, by being able to talk and to have a discussion with her father, not about anything that would be negative toward the mother, but just on the positive side of what Ms. Poirier can accomplish. She's going back to school. She's doing a virtual classes, but her grades have improved. She's got a stable environment. She's got a very loving father. They're not wealthy, obviously, but whatever she needs, he manages to get to be able to accommodate her. And he's supportive in her schooling, supporting in her emotional needs, and she doesn't go to bed hungry, Judge. She has plenty to eat. She's got a lot of parental support from her father. Although it's always best to have both parents, at least you can depend, and Mr. Aviles has been her safety net up to now, Judge.
Okay. Well, I've already stated that I'm going to follow the recommendation of the ad litem. So
thank you, Your Honor.
We'll put that forth in writing. How much time do y'all need to finalize this, or will we be setting this for another status?
Your Honor, in her interest, in my client's interest rather, I would suggest to the court that we maintain the case as pending so that Your Honor still has jurisdiction to render any orders that may be needed in the future.
Okay. I want to do a status on August 25th
Your Honor?
At 11 a.m. Yes, ma'am.
Your Honor, may I speak? May I say something real quick?
Yes.
If I'm allowed to?
Yes,
If
ma'am.
I'm allowed to say something to my child, I know she's listening. If the courts allow me to, I want to tell her that I'm always going to be here, that I'm her mom, that I don't hate her, that I don't have nothing against her. I'm always going to be her mother, and she's my daughter. There's nothing that I'm going to tell her because I know the truth. My conscience is clean. And I'm just going to let you, the courts made the decision. I'm just going to let God and life take his road. But I'm here. She can call me anytime, any day, and I'm always going to be her mom. Right now, I'm the bad guy in the picture. But one day, as she's a daughter right now, she will be a mom. And if this is my goodbye to her, and she does not want to see me again, that's fine. But I trust Jesus. And in the name of Jesus, my daughter will be back.
Hopefully,
And my
Judge,
daughter will be happy.
Hopefully, Judge, there's a path that this court can certainly help navigate. to achieve the ultimate objective of a healthy relationship between my client and both the parents.
Okay, given the circumstances that that are that we're under, usually I would request that all parties sign off on the order, but just submit it for my signature, Ms. Richardson, and just
Your Honor, I will do that.
and just make sure that it just CCs the parties. Ms.
Certainly.
Ortiz, do we have a good email address for you?
Yes, ma'am. It's Vanessa Ortiz 755@gmail.com.
Okay.
Wait.
Vanessa
Ortiz 755@gmail.com.
And Ms. Ortiz, Vanessa is with 2 S's, correct?
Yes, ma'am.
Okay.
Okay. Ms. Richardson, are your fees being taken care of by the parties?
Shoot, Judge, I wish I had an answer. I'm not altogether certain, but if I need to address it with the court, if I'm unsuccessful with the parties, I'll let Your Honor know.
Okay, just let me know.
Thank you, Judge.
Okay, that'll be the order of the court, and I'll await your order for signature, and we'll see you back here on August.
And Your Honor, if I may, I hate to interrupt you. If you could give me a deadline certain so that I have that to guide me. Can I have maybe till Friday at 5? Would that be okay?
Well, usually I give everybody at least, we'll check in on them in 2 weeks. So I'll do July the 16th.
Okay.
We'll do a tickler. We'll set a tickler for July 16th to see if it's been submitted. And then we'll remind you at that time if it hasn't been.
Very well.
Because I know how it goes. Okay.
Thank you, Judge.
If
Thank
nothing
you, Your Honor.
further, the parties are excused.
Thank
Thank
you.
you, Judge. Take care.
Thank you, likewise. Okay, on F 3415-18-9, on number 19 on the court's docket, were they just submitting an order granting? That was on a motion to withdraw.
Let me verify, Your Honor.
Okay.
It is on file, Your Honor.
Okay, go ahead and send that to my queue. I will sign off on the order granting. Let me just double check. Okay. On F 2100-20-9, I know Rule 11 was filed. Did they file their order resetting hearing yet?
Not as of right now, Your Honor.
Okay, we're gonna double check at the end of the day and let me know.
Yes, ma'am.
Okay. Okay, that should conclude this morning's docket.